Sup, players? Good morning. Happy Friday. Happy Friday. Good morning to you all. I am glad to see you. I am glad to be here with you. It is Friday, May 16th, and it is day 17 of Karen Reed's second trial. We are making our way through the trial. If this one goes the way that last year did, that means that we are halfway through now. But who knows if this one will go the way that last year did. Good morning. Sup, players? I am so glad to see you. OnlyFan has arrived. OnlyFan is here in the building. Y'all, today is going to be a day. I just have a feeling. I could be wrong. I could be. I have a feeling that today is just going to be crazy. I really do. I feel like it's going to be one of those days where I have a tab open somewhere that's, oh, yep, there it is. I have a feeling that today I'm wondering if she's going to rule on the stuff from yesterday, and I have a feeling that she might, and I have a feeling that we're all going to be annoyed. That is what my feeling is at this point. I could be wrong. Y'all tell me in chat, what do you think is going to happen? I just feel like today it's going to be, and you know why? Probably because I haven't had any sleep. That's probably why. Because I'm like, you know what? I am not emotionally prepared for rulings that are going to make me angry. And so that means that there will probably be all these rulings that make me angry. But, you know, we'll see how it goes. Hello, Alexandra. I'm catching up from yesterday. Oh boy, it's a doozy. I don't know if y'all saw the recap. I don't think we got the recap out until a little bit later. But I don't know if y'all saw the recap of Brennan spiraling. It was amazing. Hello, Steve and Wendy. Hello to my father-in-law. Hello. All the friends and family up in the house. Good morning. I was just about to ask if you were MIA. I was just pushing every minute that I possibly had, trying to get other stuff done. I stretch it. Plus I know, Auntie Bev's never on time. So, I try to stretch until right at 8 o'clock, because at 8 o'clock here, 9 o'clock Eastern. How's graduation? It was great. I got to, we had like a get together at my best friend's house after. And so I got to see my niece. She was so excited. And I got to see my friends that I haven't seen in a while. And then I left there and went and saw my mama and hung out with my mama for a little bit. So it was great. What will happen? Rending of garments, gnashing of teeth, wailing of women. Yeah, all of that. Brandi, aren't you on vacation? No. I won't get vacation until after the trial's over. I'm here. I'm just working the entire time I'm here. I came in for my niece's graduation, but I will be working the whole time. I'm not the whole time. I am going to try to take some time tomorrow and actually see my friends and family for a little bit while I'm here. If I can get enough of the podcast done tonight when we're done here. Don't lie to us. You're sitting on the beach. I wish. Someone forgot to change Hank's batteries yesterday. Oh yeah, we hit 25K subscribers. That's amazing. Very excited about that. sometime overnight or this morning. Very exciting. Woke up early for today. Good morning. Yeah, I'm still eating too. FYI. I haven't had time to do anything else. Crazy H, good call. First thing when they come in. I'll give you Lucy Cam because she's done eating now. There's Lucy Cam. Lucy! Oh, she heard me call her. I wasn't calling you. I was just saying hi, baby. Hi, baby. Bedro said last night that Bev should not allow, but if she does, they need to move for a mistrial for the record. I was thinking about this yesterday. So I think about, and she'll deny it, but think about what a big deal that is. Like, just hold on. Let me get chat. Hold on. Oh, I hate when I hear myself. I gotta pop out chat. This over here. This over here. I'm still getting my life together over here. Just ignore me. But think about what a big deal that is. The defense has literally gone through this whole process, building their case and building their, doing their cross-examinations and all of this stuff based on what the prosecution has been saying. And now the prosecution wants to come in right before the end of trial and be like, JK, we're changing it up because you caught us. Our timeline doesn't make sense. So we're going to change it yet again. Don't mind us. That's wild. That is wild. Wild. And if she allows it, that'll tell us a lot. Razor burn.
You are unmuted.
Thank you. So I need to see counsel at sidebar, please.
Of course you do. Of course you do. Don't mind us. We'll just wait right here, Bev. Happy Friday. Happy Friday. Jurors, I apologize for the delay, but you know that anytime we leave you waiting, it's because we're in here doing work. We just want to make things streamlined for you. I have to ask you those 4 little questions. No, Bev, let me ask you some questions. This is par for the Commonwealth case, so they have changed the impact time at least 4 times in its 2 cases. Remember, in openings last year, Lally said 12:45. Hello, wild child. Sup, playa? What happened to cause a mistrial? Well, we'll see. It depends on her ruling. The prosecution wants to change their timeline again because the defense is like, hey, it doesn't make sense. It doesn't work. Now they're like, oops, my bad. What we meant to say. Brandi, your spreadsheet is awesome. How do you go about updating it? I update it as we're going. I have not updated some of the witnesses, though. Sometimes I don't do that as we go. I mean, I do on like the main thing, but on the witness sheet. Sometimes I only do that every couple days because then I have to go through and take screenshots and all that. So I do that as I'm working on the podcast because then I'm pulling everything back up again anyway. Because y'all can see it when I screenshot. So then I try not to screenshot too often unless I'm like, okay, I'm just going to put this in the spreadsheet. So I try not to do it too often because I know it makes the screen go dark. It's a minor inconvenience, but you know. Good morning. Since yesterday, I couldn't stop singing Taste the Biscuit. My family definitely got tired of it quick. Taste the biscuit. Tastes good. Somebody sent me a DM and said, were you really having a breakdown? I was like, yeah, kind of. Yep. Just buckle up. We'll get there again. We're halfway through the trial. Sleep deprivation has started to kick in. I'm only mildly crazy at this point. Buckle up, Buttercup. We still got another couple weeks. I'll be full on space cadet by the time we're out of here. How does their behavior continue to go unchecked, and how quick is the Court of Appeals going to overturn if there's conviction? To get something overturned is very difficult. However, they sure are piling on some reasons, aren't they? Hi, babe. Hello. Good morning. I miss you. I'm having to feed myself. Chat daddy. Good morning. I think Brennan hates his role as prosecutor. Didn't he say that the Commonwealth has the right to present evidence beyond a reasonable doubt? That's not his right. It's his responsibility. And how many times does he say what he's entitled to? The Commonwealth is entitled to this and that. Look, every time he talks about what he's entitled to, it just makes me want to, like, I'm not saying like anything badly. I just want him to like stub his toe or something, you know, like just, not a fan. Not a fan. Not a fan. Loving this energy. I told y'all I am always the sassiest on Fridays because by Friday, when I've only had 3 hours of sleep every night this week, snark sets in. People are saying Karen wasn't sick. The defense just needed time to read the report. Isn't that funny? And then they call everybody else conspiracy theorists. Bias Bev sounds annoyed. Heck, are we all? We are already annoyed with you. Yeah, I am in a constant state of annoyed. I still vote Brandi to play Bev in the movie. Maureen Hartnett needs to play Bev in the movie. She's got it like right on. Right on. Good morning. You definitely have spicy Brandi today. The defense has a right to mount a vigorous defense and a strong rebuttal. Yes, they do. And especially when the Commonwealth keeps trying to change things every time they get caught with like this doesn't make sense. And they're like, oh, you right. Here, let me change it. I can tell you update as you go based off the raw reaction and notes. Look, what you're getting here is professional Brandi. I mean, okay. I mean, perfect. I mean, you know, what you're getting here is Brandi. What is in my spreadsheet? Because that spreadsheet is my personal spreadsheet with my personal notes that I use. So that is in no way a representation of anything other than, some of the raw reactions are like, WTF, he's full of, I mean, we listen and we don't judge. I should probably go in and edit that actually, since I haven't. No, it's fine. I don't even know where all I put it. It's fine. Everything's fine. I do get very mad. I think what was a couple days ago, I think I put in my notes, something about, what was it? Hold on, let me look. I remember thinking like maybe I should go back and change that later. It was something about Brennan. Of course it was something about Brennan. I can't remember, but whatever it was, I remember thinking, whatever, it's fine. Everything's fine. I was like, we have a side bot. We have a side bot every morning as soon as we're ready to get going. And they just keep us waiting every morning. What's up, players? Why don't they change the judge for a mistrial? They tried to change her even before the last trial. Had to have her recuse herself. She's like, nope, I'm good. Did you see all this stuff about Koberger's case yesterday? The judge is mad. I saw that. And the judge was like every police officer, everybody who has anything to do with anything, preserve your phones, preserve your texts, preserve this, preserve that. And I want to know everybody who has talked to anybody because, they're leaking information or whatever. Yeah. Imagine that. Imagine a judge laying the law down in a way that's whatever. I am going back to listen to all the podcast episodes. So good. Thank you. Thank you. It is I'm very proud of my podcast. I am very, very proud of my podcast. Have you seen all the AI babies videos? They are hilarious and adorable. Yes. My sister-in-law sent me one yesterday, and I was like, what is this? This is adorable. And that little baby Bev looks just like her, but not nearly as annoying. Some kids, let's be honest, we can be honest with each other here. We listen and we don't judge. Some kids are annoying. And they're screaming at a table next to you or something, like the ones that are hateful to their parents and stuff. So some kids, you just, they're not the best, some of them. But those little babies are so cute. They are so cute. And even little baby Bev with her little robe. Oh my gosh, it was so cute. So cute. I'm loving all the little AI babies. Appeals are expensive and they take forever to review. The process is so long. Hey, Chat Daddy. Did you see Lawyer You Know's take on the Commonwealth expert changing the time? It's a bigger deal than I realized. I did not have a chance to watch it, but I would like to. Yeah, I got it is a huge deal. I do want to watch Peter's take. I want to see it from a legal perspective, but it is a huge deal because that's their entire case. Think about all of their cross-examinations and everything that they've done has been based on this. Now they're just going to try to scooch on in there and be like, oh, never mind. Here's an updated list since you caught us.
Hey. All persons have any business before the
wild.
Justice of the Norfolk Superior Court, before the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. The court is now open. You may be seated.
Slick, I want you to start waking me up that in the morning.
Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. So I appreciate your patience. I have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? I have one other important instruction for you folks. And it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk, don't make any facial expressions.
Oh,
no
she's mad because they've been
muttering under your
giggling.
breath, no audible noises, because people need to hear what's going on and to understand.
Oh.
So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that. And out of respect to the lawyers who worked so hard to get this case before.
Oh.
Thank you very much. With that, Mr. Brennan, your first witness, please.
Or if I could begin by offering a stipulation that's agreed to between the parties.
Okay, can we turn the AC down, please?
She's like, look, y'all see that this case is BS and y'all keep laughing. Just don't do that. Brandon's getting mad.
Yes.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Reed, the defendant in the above captioned matter. Both parties respectfully stipulate to the following. The 2 Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
Thank you.
Watson.
Yes, thank you.
Watson.
With that, Your Honor, I'd like to introduce and play clip number 21.
Okay. Oh, turn the AC off. Hold on 1 second, please. I just want that.
That's not what she said, though, is it? Did you say Trooper Connor and Trooper Keefe or something?
Can the jurors hear better with that on?
So John's laying there on his left and his right, and I approach John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Trooper Watson.
So we need this marked.
Yes. We have the item.
169.
Mr. Lally, your next witness.
Your Honor, the Commonwealth calls Andre Porto to the stand.
She hasn't given us the decision yet. She might issue that ruling later.
Also, the honesty of the court and jury in the case now hearing to the truth, the whole truth, and nothing but the truth. So help me God.
Morning. Hey, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
Yeah, my name is Andre Porto, last name spelled Porto.
And what do you do for work, sir?
I'm a forensic scientist too in the DNA unit at the Massachusetts State Police Crime Lab.
And where did you go to school?
I received my undergraduate Bachelor of Science in Microbiology from the University of Massachusetts in Amherst. And then I received a Master of Science in Biomedical Forensic Sciences at the Boston University School of Medicine.
Now, following your education, where did you go to work?
I started at the Massachusetts State Police Crime Lab in the DNA unit.
And how long have you worked at the state lab?
Slow down.
Oh, yeah, sorry.
How long have you worked at the state lab, sir?
Since September 2019.
Now, when you joined the lab, what was your position and title that you were initially hired for?
I was hired as a Forensic Scientist 1.
Now, can you please explain to the jury your duties and responsibilities as a Forensic Scientist 1?
Sure. So a Forensic Scientist 1 is a training position where we're hired and we undergo an extensive training program where we do undergo the analysis process in training casework samples, where we learn how to do the lab work and analyze profiles. And at the end of this training, I took a competency test to make sure that I was able to accurately conduct the DNA analysis process. And once I passed that, I was then put on to do casework. And a year after completing both my competency tests and a year after my hire date, I was then promoted to a forensic scientist 2.
And so you're currently a forensic scientist 2, is that correct?
Correct.
And what is the difference between a forensic scientist 1 and a forensic scientist 2?
So a forensic scientist 2 is just the automatic promotion that you get after a year of hire and passing the initial competency test. And we're able to do the DNA process in casework samples.
Now, so what type of analysis do you currently do at the Massachusetts State Police Crime Laboratory?
I can do the DNA analysis process in casework and known samples. That includes the lab work as well as analyzing the DNA profiles that are generated from the work.
Now, first, just in general terms, but specifically with reference to DNA analysis, can you explain to the jury how is that analysis performed?
Sure. So there's 4 steps in the analysis process. The first step is extraction, where we apply heat and chemicals to the samples to break open the cells and release that DNA to be available for use. Step 2 is called quantitation, where we take a small sample of that extracted DNA to estimate, and we use chemicals and run it through an instrument to estimate how much DNA we extracted. And then we proceed to step 3, which is called amplification. And that's basically, think of it as a molecular photocopier, where
This is y'all are asking. So he's the DNA dude. He testified last year too. He swabbed. He had the swab from the taillight, and then the root end of the hair from the back bumper, but I think they couldn't find anything on that. And then he talks about the DNA on John's clothes.
we target specific areas of the DNA to make
And the drinking glass.
millions of copies of it, and then we run it through, go to detection, where we run it through an instrument, and we generate the DNA profile as an electronic file on a computer.
Now, is the state lab where you work accredited?
Yes, it is.
And by whom?
We are accredited by an organization called ANAB, which stands for ANSI, National Accreditation Board, and ANSI stands for American National Standards Institute.
I need you to slow down, please. Please.
Sorry.
Listen.
Now, Mr. Porto, are there steps taken in your lab during that process that you were just explaining to prevent against contamination?
Yes, there are.
And can you explain what those are?
Sure. So there are various steps. One step to prevent contamination between analysts would be to bleach and wipe down the workstations before use and after. Another way to prevent DNA transfer from analysts to the samples is to wear personal protective equipment, such as lab coats, gloves, masks, hairnets, and beard guards. And a way to prevent transfer from sample to sample would be to frequently change gloves, as well as only have one sample open at a time.
Now, with your work at the lab, is there a review process that your work undergoes?
Yes, there is.
And can you describe that process to the jury?
Sure. So once I complete my work, the file undergoes 2 types of reviews. The first is a technical review, where another qualified analyst will take the file and they'll do their own independent assessment and make sure that they come up with the conclusions and that they agree with the conclusions that I reached. And they'll also make sure that all the protocols were followed and every decision is scientifically sound. Once that review is completed, it undergoes an administrative review, where another qualified analyst will then look through the file and they look for clerical errors, such as typos or missing page numbers or missing case numbers. Once those 2 reviews are completed, the results can then be reported out.
Now, as a part of that accreditation process that you were speaking about a few moments ago, do you undergo anything called proficiency testing?
Yes, I do.
And can you explain to the jury what that proficiency testing process consists of?
Yeah, so a proficiency test is a test that's administered twice a year by an external vendor. And the results of this test are not known to the analyst at the time. And we basically treat it like it's a real case, where it undergoes the analysis process as if it were a real case. And this test is used to show that the analyst is demonstrates ongoing competency in the DNA analysis process. and successful completion of the test is required to maintain qualification as an analyst.
And what areas do you specifically undergo proficiency testing in?
DNA analysis.
And have you successfully completed each of those proficiency tests that you've taken?
Yes.
Now, Mr. Porto, could you explain to the jury what exactly is DNA?
Yeah, so DNA stands for deoxyribonucleic acid, and it's basically the building block that makes us who we are. We each have 2 copies of our DNA, one that we inherit from mom and one that we inherit from dad. And that this combination makes sure that, barring with the exception of identical twins, we all have different DNA.
And is DNA the same in every cell of a person's body?
Yes. So what that means is, if I were to take a blood sample and a saliva sample from the same person, the same DNA profile will be generated.
Now, you spoke a bit earlier about the different steps included in the DNA testing. If you could, just a little bit slower, go through each of those 4 steps again for the jury.
Sure. So like I said, it's a 4-step process. So extraction, quantitation, amplification, and detection. So extraction, we use chemicals and heat to burst open the cells to make that DNA available for use. Quantitation, step 2, we take a small sample of that extracted DNA. We use a different set of chemicals and an instrument to estimate how much DNA is available for use. Amplification is the 3rd step, which I mentioned is the basically molecular photocopier, where it makes millions of copies of specific areas of the DNA. And then the 4th and last step is detection, where we run those amplified copies through an instrument, and we generate the DNA profile as an electronic file on the computer.
Now, Mr. Porto, what is STR?
So STR stands for short tandem repeats, and they're the locations that we're making the millions of copies of.
Now, in your work at the lab, do you have something that's referred to as a known item?
Yes.
And can you explain to the jury what a known item is?
Sure. So a known item is an item that's taken directly from a person to be used as a reference sample, so we know what the source of that profile is.
And conversely, what is a questioned item?
A questioned item is an item that's taken, let's say, from a crime scene where we don't know what the source is.
Now, do you also have terminology within your lab as far as a parent versus a child item?
Yes, we do.
And can you explain how those labels are and how they reference to what you do in your work?
Sure. So a parent item is, for example, the original item, and the child is a sample of that item. So for example, this box of tissues would be the parent item, and if you were to swab the outside, the swab would be the child item. So the box of tissues would receive, let's say, an item of 1-1. The swabbing of the outside would receive an item of 1-1.1.
Now, what are positive and negative controls?
Yeah, so a positive control is a control that has it's a known sample with a known DNA profile that we use in every step of the DNA analysis process to make sure that each step and instrument worked as expected and properly. And then a negative control is a sample that has no DNA in it. It only receives the chemicals that we use. And that's to ensure that the chemicals that we're using don't have any DNA inherent to them.
Now, when you as an analyst or forensic scientist too are assigned work within the DNA unit, where do you retrieve that evidence from?
Yeah, so I retrieve it from a locked cold room that's only accessible via keycard.
Now, why are items kept in cold storage?
Yeah, the cold storage helps preserve the DNA for long-term storage.
And as far as the heat versus the cold, why is it that it's specifically kept, or why does the coldness of the storage room help preserve the item?
The cold can help prevent, let's say, growth of bacteria and mold that can degrade DNA.
And what does heat do conversely in reference to an item of forensic value?
Heat can help degrade DNA, and also promotes bacterial and mold growth that can further degrade that DNA.
Now, when you receive an item from the cold storage, how is that item typically packaged when you retrieve it from there?
Sure. So the item comes in these plastic, clear, transparent plastic sealed containers that has a label with a case number on it. And inside of that, each sample is within like a small plastic tube that has a label with a case number and item number.
Now, at some point, were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes, I did.
And what type of work in general terms were you assigned to do in this case?
I was assigned to do the DNA analysis process.
And that was on several items, is that correct?
Correct.
And could you explain to the jury the sort of the process that you used to analyze evidence in this case?
Sure. So the case underwent the 4 steps that I explained before. So extraction, quantitation, amplification, and detection.
And there was a known standard that was done in this case, specifically in item number 8-1.1.1. Is that correct?
Correct.
And did another analyst test and report the results from the known blood standard from that item 8-1.1.1?
Correct.
And how is that done?
Yeah, so that undergoes the same process that I explained. It'll go through the 4 steps: extraction, quantitation, amplification, detection. And then the analyst that did the interpretation and reported that out, the known standard out, they went through the profile to make sure that it's one from one person or single source. And once that went through the review process that I explained, so technical and administrative review, and once that was all completed, the standard was available to be used for comparisons.
And to whom was that known standard identified as belonging to?
John O'Keefe.
Now, you used the word in there as far as a single source. Can you explain to the jury what your understanding of that term is based on your training and experience?
Sure. So a single source is just a DNA profile that has one contributor to it. So only one person contributed DNA to that profile.
What exactly is a DNA profile?
Yeah, so a DNA profile is basically the combination of all of the locations that we amplified during the 3rd step of the process. And it's basically, you can think of it as like a chart, like an EKG, where it has peaks and valleys, and each peak has a specific number. And the DNA profile is just a combination of all those numbers put together.
Now, can you explain to the jury in general terms, to start with, the process of comparison between a known standard and a questioned or unknown standard?
Sure. So first, I did the analysis on the question items. I did the 4 steps. I analyzed the profiles that were generated. I then interpreted, make sure that I could determine the number of contributors. And once that was completed, I then used the standard that was available and compared them to all the profiles that were suitable for comparison.
Now, sir, starting with item 3-1.1, what was that a sample from?
That was a sample from taillight passenger.
And from a specific vehicle, is that correct?
Correct.
And what, if any, information were you given as to that vehicle that the swab from the taillight was from?
Do you mean like the license plate?
Yes.
Could I refer to my notes?
Yes.
Thank you.
Your Honor, with the court's permission, this is a little detail as far as the testimony goes.
I don't have a problem. Does the defense object?
I do not object,
Okay,
Your Honor.
thank you.
Thank you, Your Honor.
So the license plate was 3G6684. Right, I'm sorry, 3GC684.
Now, with reference to the swab from the taillight, were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least, so sorry. I'll just restart. So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least 510 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, what is that?
Okay, all of that to say that the taillight had 3 DNA profiles. One of them is John O'Keefe.
mean?
So an inclusion is basically when I look at the question DNA profile that was generated, and I compare it to the known DNA profile. And if the characteristics of the known profile are consistent with the characteristics observed in the question DNA profile, that's an inclusion.
Now, as far as that number, 510 non-alien, how many zeros in that number?
So a non-alien is a 1 followed by 30 zeros.
Now, that profile, in addition to Mr. O'Keefe's profile, also had 2 unknown contributors, correct?
Correct.
Now, was that item also submitted to an outside vendor named Bodhi Technologies for further analysis?
Correct.
And with reference to your comparative analysis from the profile from this item to Mr. O'Keefe, profile. If you could again just expound upon what does inclusion mean?
Yeah, so an inclusion, I compared the known standard that I had available for use from John O'Keefe to the DNA profile generated from the taillight. And the DNA profile was consistent with the DNA profile that I observed in the questioned item. And that's what an inclusion means.
Now, regarding item 3-6, what is the description of that item?
Yeah, so 3-6 is a root end of hair from exterior passenger side rear panel.
And is that the same vehicle as far as the taillight sample?
Correct.
Now, with respect to hair in general, there's a root end and a shaft end, correct?
Correct.
And what limitations does your lab have with regard to DNA testing of hair?
So when we test hair, we're actually, the root end of the hair, we're looking at any potential skin cells that might be attached to the root end. So that's where the DNA that we're looking for is coming from. And if there's not too many, yeah.
Are you familiar with the term based on your training experience known as autosomal DNA?
Yes.
And can you describe for the jury what your understanding of that term is?
Yeah, so autosomal DNA is DNA that's located in the nucleus of the cell. And that's the DNA that we inherit from both mom and dad.
Now, are you also familiar based on your training experience with a term known as mitochondrial DNA?
Yes.
And can you please explain to the jury what your understanding of the term mitochondrial DNA is?
Yeah, so mitochondrial DNA is DNA that's found in the mitochondria of a cell. And we inherit that from the mother.
Yes.
It may be somewhat evident, but could you please explain to the jury sort of the difference between autosomal DNA on the one hand and mitochondrial DNA on the other?
Yeah, so like I said, the autosomal DNA is the one that we have 2 copies of, where we inherit one from mom and one from dad. And then the mitochondrial DNA is a circular DNA that we just inherit from mom.
Now, is the Massachusetts State Police Crime Lab equipped to perform mitochondrial DNA testing?
No, we're not.
Now, was the DNA extract from the hair also sent to that external vendor, Bodie Technologies in Lorton, Virginia?
I'm not sure if the extract was sent, but I know that the shaft of the hair was sent to Bodie.
Now, what testing did you perform on the hair?
I did the regular DNA analysis process on the root end of the hair.
And that was done prior to it being shipped to that external vendor, is that correct?
Correct.
And what conclusions were you able to draw from the testing that you did on the hair?
Yeah, so there was no human DNA detected and STR analysis was not performed.
Now, what does that mean, sir?
Yeah, so it means that I didn't detect any human DNA. So there might be DNA on there, but it was below what our instrumentation could detect.
Okay, so that right there is what sent the world into a frizzy before the last trial, because when he tested that hair, the little hair that could, there was no human DNA detected. So then that got brought up in the pretrial motions, and then this huge litigation battle broke out between the prosecution and the defense over it.
Now, turning your attention to item 3-2.1.1, what is the description related to that item, sir?
It's a sample from the exterior of broken drinking glass.
And is there any further indication as far as the broken drinking glass, as far as where it was recovered?
Oh, yeah, 34 Fairview Road.
And were you able to generate a DNA profile from this item, the drinking glass?
Yes, I was.
And from your comparative analysis from this question item to that of the known standard of John O'Keefe, what did you conclude?
Yeah, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 530 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This supports an inclusion.
This is the last time I'll ask you this, but just if you could reiterate to the jury, what does an inclusion mean?
Yep, so an inclusion is when I compared the known standard to the question item, and if the profile in the known standard is consistent with the profile in the question profile, that's an inclusion.
And that
Case of threes.
number again, as far as 530 non-alien, how many zeros again in that number?
That's a 1 followed by 30 zeros.
Now, sir, if I could turn your attention to another item, 7-1.2.1, what is the description related to that item?
Sample from stain A on upper right leg of jeans.
And is there any further indication as to whom those genes belong to?
John O'Keefe.
Now, were you also able to generate a DNA profile from this item, the stain A on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from the question item to that of the known standard of John O'Keefe, what did you conclude with reference to that item?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributors 2 and 3 are not suitable for comparison. The DNA profile from this item is at least 570 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. Now, turning your attention to item 7-1.3.1, what is the description related to that item?
Sample from stain B on upper right leg of jeans.
And same genes as the previous item?
Yes.
Now, were you able to generate a DNA profile from this item, stain B on the upper right leg of the jeans of Mr. O'Keefe?
Yes, I was.
And from your comparative analysis from this questioned item to that of the known standard of John O'Keefe, what did you conclude?
Yep, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 660 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.4.1, and again, these items with the dash and the point, is that what you were referring to earlier as the parent-child relationship between items?
Yes.
And what is the description for 7-1.4.1?
Sample from stain C on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain C on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis of this question item, stain C, to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile is a mixture of at least 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile was interpreted as a mixture of 2 contributors. The DNA profile from this item is at least 830 non-alien times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.5.1, what was the description of that?
Sample from stain D on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain D on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from this item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 670 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also do some testing on an item 7-1.6.1?
Yes, I did.
And what was the description associated with that item?
Sample from stain E on upper right leg of jeans.
And were you able to generate a DNA profile from that item, stain E, on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from that question item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides a support for an inclusion.
I used a different number there as far as a decillion. How many zeros is a decillion?
Yeah, a decillion is a 1 followed by 33 zeros.
Now, with each of those items that you just testified about as far as the genes, the question items from the stains on Mr. O'Keefe's jeans, those were each located on the right leg, correct?
Correct.
Now, did you also perform some analysis on item 7-1.7.1?
I did.
And what is the description associated with that item number?
Sample from unstained areas of the exterior of jeans.
Now, were you able to generate a DNA profile from that item from the unstained areas of the exterior of Mr. O'Keefe's jeans?
I was.
And from your comparative analysis from this questioned item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 4 contributors, including male DNA. The DNA profile from this item is at least 53 septillion times more likely if it originated from John O'Keefe and 3 unknown individuals than if it originated from 4 unknown, unrelated individuals. This provides support for an inclusion.
And again, sir, with that number, as far as 53 septillion times more likely, how many zeros in a septillion?
A septillion is a 1 followed by 24 zeros.
Now, sir, if I could turn your attention to
I'm taking notes to make it.
what's listed as number 12 in your report, but item 7-18.4.1. Did you do some testing on that item as well?
Yes.
And what was the description associated with that?
Sample from stain C on top front of Gray's long sleeve shirt.
And the gray long sleeve shirt, is that attributed as belonging to a specific person?
Yes, John O'Keefe.
And were you able to generate a DNA profile from that item's specifically sample from stain C on the top front of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that questioned item from the shirt to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originated from a single contributor. The DNA profile from this item is at least 58 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And again, sir, that number, as far as 58 octillion times more likely, how many zeros in an octillion?
So an octillion is a 1 followed by 27 zeros.
Now, sir, if I could take you down to listed as 15 in your report, but did you do some testing on item 7-18.14.1?
I did.
And what was the description associated with that item?
So sample from stain L on back bottom right of gray long sleeve shirt.
And were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis with reference to that item, the sample from stain L on the back bottom right of the gray long sleeve shirt, in comparison to the DNA profile from the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 2 contributors, including male DNA. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also perform some analysis on an item numbered 7-18.17.1?
I did.
And what was the description associated with that item, sir?
Sample from unstained areas of exterior of gray long sleeve shirt.
And similarly, were you able to generate a DNA profile from that item, the sample from the unstained areas of the exterior of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 960 nonillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. I'm going to group a couple, 4 separate items from your report, starting with what's listed in your report as number 9 is item 7-3.1, correct?
Correct.
And what is the description associated with that item, sir?
Sample from stain D on right instep of sneaker.
And 11 from your report, you also did some analysis on item 7-18.3.1, is that correct?
Correct.
And what was the description associated with that?
Sample from stain B on top front of gray long sleeve shirt.
And item 7-18.7.1, do you see that as well?
Yes.
And what was the description associated with that item?
Sample from stain F on top front of gray long sleeve shirt.
And lastly, in this group, item 7-18.8.1, what was the description associated with that?
Sample from stain G on back left sleeve of gray long sleeve shirt.
And with respect to each of those last 4 samples from those items, were you able to generate a DNA profile with respect to each of those 4?
Profiles were generated from them.
And what did you conclude based on the generation of those profiles with those 4 items?
Yeah, so the profiles that were generated were not suitable for comparison.
And if you could explain briefly to the jury, when you say not suitable for comparison, what do you mean by that?
Yeah, so for 7-3.1, it was a mixture of at least 5 contributors. And at the DNA unit, we validated, basically we tested and make sure that our protocols were we can only interpret mixtures of up to 4 contributors. So I determined that there were 5 contributors, so that makes it too complex for us to do comparisons to it. So it's not suitable for comparison for that reason. And the other 3 items, due to the quality of the profile, they were not suitable for comparison. And basically what that means is that there were such low amounts of DNA that was in the sample that there was a lack of information from the profiles themselves, so they weren't really suitable for comparisons.
And just to be clear, the item that you're referring to with the 5 possible contributors, that's a shoot, correct?
Correct.
Now, if I could turn your attention in your report to what you have listed as number 10, there are a number of different items listed there, correct?
Correct.
And starting with item 7-17.2.1, what is the description associated with that?
Sample from stain A on top front left of orange t-shirt.
And 7-17.3, what is the description associated with that?
Sample from stain B on top of front left of orange t-shirt.
And item 7-17.4.1, what is the description associated with that?
Sample from stain C on top front left of orange t-shirt.
And item 7-17.5.1, what is the description associated with that item number?
Sample from stain D on front bottom right of orange t-shirt.
And item 7-17.6.1, what is the description associated with that?
Sample from stain E on back left shoulder of orange t-shirt.
And so each of those respectively were samples taken from stains on the orange t-shirt of Mr. O'Keefe, correct?
Correct.
Now turning your attention to item 7-18.2.1, what is the description associated with that?
Sample from stain A on right sleeve of gray long sleeve shirt.
And item 7-18.5.1, what is the description associated with that?
Sample from stain D on center front of gray long sleeve shirt.
And item 7-18.6.1, what is the description associated with that?
Sample from stain E on center front of gray long sleeve shirt.
And item 7-18.9.1, did you generate a profile from that item as well?
Yes.
And what is the description associated with that?
Sample from stain H1 on back left of gray long sleeve shirt.
And item 7-18.10.1, what is the description associated with that?
Sample from stain H2 on back left of gray long sleeve shirt.
And item 7-18.11.1, what is the description associated with that?
Sample from stain I on back right shoulder of gray long sleeve shirt.
And item 7-18.12.1, what is the description associated with that?
Sample from stain J on back bottom right of gray long sleeve shirt.
And lastly, with this group search, item 7-18.13.1, what is the description associated with that?
Sample from stain K on back bottom right of gray long sleeve shirt.
And so each of those items beginning with 7-18 were associated with various stains taken from various areas on the gray long sleeve shirt of Mr. O'Keefe, correct?
Correct.
And with respect to each of those areas of the orange t-shirt and the gray long sleeve shirt, were you able to generate a DNA profile from those items?
I was.
And from your comparative analysis of each of the DNA profiles from those items to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originating from a single contributor. The DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
Now, again, if you could just remind the jury, when you say single source contributor, what does that mean?
Yeah, so a single source profile is a profile that has one contributor to it. So like one person contributed DNA to that profile.
And with respect to the number as far as 490 octillion times more likely, how many zeros are in that number?
So an octillion is a 1 followed by 27 zeros.
Now, lastly, sir, did you perform any analysis with reference to items numbered 8-2 and 8-3?
I did.
And what were the descriptions respectively for items 8-2 and 8-3?
So item 8-2 was right hand fingernail clippings from John O'Keefe. And item 8-3 were left hand fingernail clippings from John O'Keefe.
So fingernail clippings from both the right and left hand of Mr. O'Keefe.
Correct.
And were you able to generate a DNA profile from those item numbers, the right and left hand fingernail clippings of Mr. O'Keefe?
I was.
And based on, from your comparative analysis of the DNA profile from the right and left hand fingernail clippings, both of Mr. O'Keefe, taken in conjunction with the known standard of John O'Keefe, what did you conclude?
Yeah, so the male DNA profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
So with respect to each the right and left hand fingernail clippings of Mr. O'Keefe, both of those were identified by you or your analysis as a single source contributor, correct?
Correct.
And they were each 490 octillion times more likely to have originated from John O'Keefe than from an unknown, unrelated individual. Is that correct?
Correct.
Thank you. Thank you, sir. I have nothing further on. Anyone?
Yes.
Good morning, sir.
Good morning.
Mr. Porto, I would like to start by asking you about item 3-1.1, which you've identified as a sample from the passenger side taillight of the vehicle. Can you orient yourself in your report to that item?
Yes.
And that, of course, was the passenger side taillight that was attached to the vehicle, correct?
Correct.
You were never asked to do any DNA comparison on any pieces of taillight connected with this case, correct?
Let me check my other report. For taillight, there was another item that was item 3-3.1, which is sampled from apparent glass on rear bumper, if that's what you're referencing.
Okay, so if I suggested to you that the taillight was plastic, that glass wouldn't have been the taillight, correct?
I don't have, that's beyond my scope of testing.
Gotcha. Okay. With regard to the passenger side taillight, you found that there were 3 contributors of DNA to that taillight attached to the vehicle, correct?
Correct.
One of those contributors appeared to be John O'Keefe. Is that fair to say?
He was included
All
into
right.
the profile.
With regard to the other 2 contributors, who were they?
They could be anybody.
Were you ever asked to compare DNA samples from either Canton Police Detective Kevin Albert or Canton Police Chief Kenneth Berkowitz to the DNA profile that you analyzed from that passenger side taillight?
I was not.
Now, with regard to the broken drinking glass, which is item 3-2.1.1, do you see that in your report?
I do.
With regard to that, you came up with a DNA profile that also had 3 contributors, correct?
Correct.
One of those contributors appeared to be John O'Keefe, correct?
He was included, correct.
Who were the other 2 contributors?
I don't know. They could be anybody.
Were you ever asked with regard to that broken drinking glass to compare the DNA profile that you analyzed with the DNA of either Boston Police Sergeant Brian Albert or ATF agent Brian Higgins?
I was not.
Now, with regard to 7.1.2.1, or maybe it's 7-1.2.1, that's the stain A from the upper right leg of the jeans?
Correct.
All right. And you were aware, you were told that those were the jeans that John O'Keefe was wearing on the morning in question when he was found?
Based on the sample description, that's what it seems.
All right. And it turned out that his DNA was on his own jeans, correct?
He was included in the profile.
All
from
right.
that
And
item.
that was unsurprising to you, correct? And with regard to that item, you found that there were 3 contributors of DNA, correct?
Correct.
With John O'Keefe being one of them.
He was included in the profile, yes.
And who were the other 2?
I don't know. They could be anybody.
Let's move on to stain B, also from the upper right leg of the jeans. That is 7-1.3.1. You see that in your report.
I do.
When you found a DNA profile, how many contributors of DNA were there?
3 contributors.
All right. And again, this was John O'Keefe's genes, correct?
Based on the description, yes.
So he was one of the 3 contributors.
He was included in the profile, yeah.
Who were the other 2?
I don't know. They could be anybody.
Moving on to stain C from the upper right leg of the jeans. 7-1.4.1. You see that in your report?
I do.
With regard to the DNA profile that you analyzed there, how many contributors of DNA were there to that profile?
At least 2, and it was interpreted as 2 contributors.
And again, this is the same pair of jeans that he was found in, correct?
Based on the description, yes.
And you said at least 2 contributors. It actually could have been more than 2.
Based on our protocols, I had to call it 2, and we determined it as 2, but it could be more than 2, yes.
Okay. Well, let's pay attention to the one that was not John O'Keefe, at least that one. Who contributed that DNA to his pants?
I don't know. It could be anybody.
Moving on to stain D, which is 7-1.5.1. And if I can just put my glasses on to make sure I've read my own writing correctly. Actually, is it 7-15-1? Did I get that wrong the first time?
D?
I'm sorry?
Do you mean
Stain D? Stain D.
Stain D is 7-1.5.1.
Oh, I had it right the first time. Okay. With regard to that stain, you also got a DNA profile. And how many contributors were there to that DNA profile?
I interpret it as 3 contributors.
And again, this is John O'Keefe's genes, correct?
Correct.
He was one of the contributors to his own genes, correct?
He was included in the profile.
And with regard to that stain on the upper right leg of his jeans, who contributed the DNA to who were the other 2 contributors of DNA to that stain?
I don't know. They could be anybody.
And then finally, with regard to that upper right leg of the jeans, there was also a stain E, correct?
Correct.
How many contributors did you find to that DNA profile?
2 contributors.
One of which was John O'Keefe to his own genes, correct?
He was included, yes.
And who was the other contributor to that stain on the jeans?
It could be anybody. I don't know.
And by the way, just for the record, that was 7.1.6.1?
7-1.6.
7-1.6.1. Thank you, sir. Okay, now, with regard to the unstained area of the exterior of the jeans, do you see item 7-1.7.1?
Yes.
You found a DNA profile with regard to that unstained area as well, correct?
Correct.
How many contributors of DNA were there to that unstained area of the jeans?
I interpreted it as 4 contributors.
And John O'Keefe was one of those, correct?
He was included in the profile.
His own genes.
Based on the description, yes.
Who were the other 3 contributors to that DNA profile?
I don't know. It could be anybody.
And before we move on to the sneaker, I just wanted to ask you a question about the passenger side taillight that I neglected to ask you. That was the one where there were 3 contributors, correct? And again, I'm going back to 3-1.1.
Correct.
Sorry to skip around, sir.
Okay.
I'm not trying to make this
all
any
right.
more confusing than it is. With regard to the passenger side taillight and that DNA profile, are you able to determine when that DNA was deposited on the passenger side taillight that was attached to the vehicle?
No, I'm not.
Are you able to testify with any certainty that it was deposited there, say on January 28th or 29th of 2022?
No, I can't.
So consistent with your analysis of it, are you able to say whether it occurred prior to January 28th of 2022?
No, I can't.
Were you aware that that vehicle was John O'Keefe's girlfriend's vehicle?
I was not.
Were you provided any information about just how often he had been in and around that vehicle prior to January 28th of 2022? So moving on to 7-3.1, which was the right instep of the sneaker, correct?
The
You see
right
that in your
instep.
report?
This is the one that had a lot.
With regard to that particular stain, you noted how many contributors of DNA?
Yeah, it was interpreted as at least 5 contributors.
And when you have interpreted as at least 5 contributors, what does that do to your ability to find out who contributed that DNA?
So based on our protocols, we're not able to do any comparisons to any mixtures that are 5 or more contributors. So it's not suitable for comparisons.
Okay, which means that with regard to the sneaker, at least, you couldn't even say whether John O'Keefe's DNA was on it, correct?
Correct.
And with regard to all 5, do you have any idea who contributed the DNA to that sneaker?
No, I don't.
Now, moving on to, I just have a couple more for you, sir. Moving on to what is labeled as stain L, which is 7-18.14.1, I believe. Do you see that in your report?
I do.
And that was a stain on the back bottom of his long sleeve shirt, correct?
Correct.
And were you told that the long sleeve shirt was his outer clothing when he was found?
I don't believe so.
How many contributors to that stain on the back bottom of his long sleeve shirt did you find in that DNA profile?
I interpreted it as 2 contributors.
And did you make any match with regard to either of those contributors or both?
I did comparisons, and John O'Keefe was included as one of the contributors.
Okay, so John O'Keefe was a contributor of DNA to his own long sleeve shirt, correct?
Based on the descriptions, correct.
All right, and whose other DNA was on that shirt?
I don't know.
And then finally, with regard to 7-18.17.1, that was an unstained area of the exterior of that shirt, correct? That same long sleeve shirt.
Correct.
And you tested that and got a DNA profile, correct?
Correct.
How many contributors were there to that DNA profile?
I interpreted it as 2 contributors.
Was John O'Keefe one of them?
He was included as one of the contributors.
Okay, so his DNA was found on his own shirt, correct?
Based on the description, correct.
And who contributed the other DNA profile to John O'Keefe's sweatshirt?
I don't know.
With regard to any of the stains on the upper right leg of the jeans, I counted 1, 2, 3, 4, 5 that you've discussed here today. Were you ever asked to compare the DNA profile with the DNA profiles of either Brian Higgins or Brian Albert?
I was not. Oh,
All right.
And your answer was you were not?
I was not.
Did anybody ever provide you with DNA profiles of Brian Higgins or Brian Albert?
Sustain to that.
If I may have one moment, Judge.
Yes.
Okay. Three -1.
I just have one more question for you, Mr. Porto, and I do want to thank you for answering all my questions here today. You wrote reports on your analysis of all the items and the work that you did on this case.
I did.
and you are directed pursuant to protocol to address those reports to somebody, correct?
Correct.
Who was it that you sent the reports to in this case?
I'm sustaining the objection.
Did you send those reports to Michael Proctor?
Sustain. Jurors, strike the question.
I have nothing further. Thank you, sir.
Yes.
Mr. Porto, based on your training and experience and years of doing DNA testing at the lab, when it comes to samples from items of clothing, is it uncommon or common to have multiple contributors?
That depends. It can happen, but it's possible, yes.
Is it something that's a complete anomaly?
I wouldn't say so, no.
Now,
I don't think he was expecting that answer.
turning your attention back to item 3-1.1, that's the sample from the passenger side taillight of the defendant's vehicle, correct?
Correct.
And Mr. O'Keefe was found to, his known DNA profile was found to be an inclusion for the DNA profile from the swab from the defendant's passenger side taillight, correct?
He was included in the profile, yes.
And to what statistical, what is the number associated with that inclusion, sir?
The DNA profile from this item is 510 non-alien times more likely to have originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals.
Now, Mr. Porter, if I could turn you back to number 10 in your report, there's a number of different items listed there, correct?
Correct.
And as far as the items listed associated with various stains on various areas of Mr. O'Keefe's orange t-shirt and gray long sleeve shirt, there's about 13 different DNA profiles that you generated in reference to those items, correct?
Correct.
And from those 13 different items, they're all from a single contributor, is that correct?
Correct. They were interpreted as originated from a single contributor.
And as far as the DNA profile, your comparison of each of those 13 different stains on the orange t-shirt and the gray long sleeve shirt, what were your conclusions again as your comparison with the known standard of John O'Keefe?
Yeah, so the profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And lastly, with reference to the fingernail clippings from both the right hand and the left hand of Mr. O'Keefe, those were also, your analysis provided for inclusion of Mr. O'Keefe's known DNA standard, correct?
He was included in the profile, correct.
And again, the profile from both the right hand and the left hand fingernail clippings was a single source contributor, correct?
Sustain.
How many sources were associated with those?
Objection.
Sustain.
Nothing further.
Okay. You all set, Mr. Unity?
Yes, Your Honor, thank
You
you.
are all set, Mr. Porto.
Thank you.
Very much.
Okay.
Who is the next witness?
Your Honor, the Commonwealth will call Ashley Vallier to stand.
Oh, here we go. This one's going to be another technical one. I'm not going to get to chat to y'all at all today because I got to be taking notes all day. All right. Let me pause this for a second because all I've been doing is staring at this, taking notes. All right. So here's the dealio. The stuff that they just went through. Hold on, and I'll make like a little graphic and put it in here for you because we all love pictures. That big group of stuff that he went through that was like this one and this one and this one and this one and this one. That was John O'Keefe's DNA was the only DNA found on some of those stains that were on the t-shirt, which it's not surprising that a lot of the ones that were only his DNA were on the t-shirt because he had, the t-shirt was on under the hoodie. Then the hoodie, let me get to the hoodie. the ones, there was like a group of, let me move this over here, a group of stains on the hoodie that were only his. Okay, which that's fine. The fingernail clippings were only his. But here's where this stuff gets weirder. The right instep of the shoe had a mixture 5 contributors. That's one of the things that the defense can say, like, oh, isn't that consistent with dragging somebody, etc. Let me get my other ones. The things I go through for y'all. I handle all the boring stuff so y'all don't have to. The tail light was a mixture of 3 contributors, which we knew that. One was John O'Keefe. And 2 unknown. The jeans, okay, that's that one. That one's that one. Hold on, let me get back up here. Root end of the hair was no human DNA detected. Okay, so the broken drinking glass had, let me, the broken drinking glass had John O'Keefe and 2 unknown. All right, and then for the jeans. So there were some jeans some stains on the jeans. On the upper right leg of the jeans, there were multiple stains that had a mixture of John O'Keefe and 2 unknown contributors. And then there was one that had John O'Keefe and 1 unknown contributor. And then there was one spot that had on the jeans that had John O'Keefe and 3 unknown contributors. So he has different parts of the jeans have different stains, but it was all John O'Keefe. Shocker, his DNA's on his jeans. And different stains had different ones. Some 1 other person, some 2 other person, some 3 other person, all on the jeans. On the hoodie, there was John O'Keefe and 1 unknown individual on some of those stains, including the unstained areas of the hoodie had him and 1 other person, and then the back bottom part of the gray hoodie had him and 1 other person. Different number. Okay, I have to put all this in my, look how much I look at how much I love y'all. I suffer through all the boring stuff for my jurors. The t-shirt was the only thing. Let me just double check one thing. Drinking glass, jeans. The underneath t-shirt was the only thing that didn't have anything from anybody else that I see. The hoodie had up to 3. Is that right? Let's see. The hoodie, individual, right leg jeans. Trying to make sure I'm not telling y'all wrong. I have to go through all of these 7-1.3.1. Jeans, hoodie. I think everything on the hoodie had, that's jeans. Hoodie. Yeah, everything on the hoodie had him and either just him or him and one unknown contributor. And the right instep, the jeans. Okay, I think that's it. All right. Here, I made this very simplified for y'all. I will put it in the spreadsheet. Oops. Stop pressing buttons, Brandi. All right, here, let me show you this real quick. Ashley Vallier is going to be very technical and very, it's fine. Everything's fine. Everything's fine. Here, let me show y'all something real quick, though. Share screen. This is, away. This breaks it down. So the t-shirt had only his DNA on it. All of those different little spots had only his DNA on it. Not surprising because it was worn under his hoodie. On his hoodie, some of the stains had only him, but there was also one other unknown contributor on some of the stains. On the jeans, it was him, and then some of them were just him. Some of them had 3 other unknown contributors. The tennis shoes had up to, or at least 5. The glass was him and 2 other people. I need to get a picture of the glass. And then the taillight was him and 2 other people. So all of that is just that. Everything that we just listened to for that entire time is just this. Okay. Now let's get back to your regularly scheduled program. Oops, Ashley Vallier. She's very technical, but that's okay. Share screen. Tab. Oops. Okay, here we go.
You solemnly swear the evidence you give the court and jury in the case down here is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, Ms. Vallier.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Ash Vallier, spelled Vallier.
And where do you work?
I work at the Massachusetts State Police Crime Laboratory.
And where did you go to school?
I got my bachelor degree in biochemistry and cell biology from UC San Diego and a master's degree in biomedical forensic sciences from Boston University.
Now, following your education, where did you go to work from there?
Directly after I got my degree at Boston University, I worked at the Broad Institute.
And what did you do at the Broad Institute?
I did quality control checks of items that potentially could be tested for pharmaceutical use.
Now, how long have you worked at the Massachusetts State Police Crime Laboratory?
A little over 6 years.
Now, is the state lab accredited?
It is.
And by whom?
ANAB.
And what does ANAB stand for?
It stands for ANSI National Accreditation Board.
And the ANSI within the ANAB, what does that stand for?
That is another acronym that I don't recall right now.
Now, as part of that accreditation process, do you undergo any sort of type of proficiency testing?
I do.
And can you explain to the jury what that proficiency testing process consists of?
A proficiency test is a test that is given from an outside agency in the discipline that you do casework in, that you would work through like a normal case, but it has an end expected result at the end.
And how often do you undergo proficiency testing?
Every year.
And what areas do you specifically undergo proficiency testing in?
I've done proficiency tests in gunshot primer residue and physical match analysis.
And have you successfully completed each of those proficiency tests that you've taken?
I have.
Now, when you initially joined the State Police Lab, what was your position and title that you were hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury what your duties and responsibilities were as a forensic scientist 1?
So forensic scientist 1 is the introductory level. It's when you start your training in whatever discipline you're going to be trained in and quality control checks. After you've been at the laboratory for over a year and you're signed off to do casework, you become a forensic scientist 2.
And you're currently a forensic scientist 2, is that correct?
Yes.
What is the difference between a forensic scientist 1 and a forensic scientist 2 at the Massachusetts State Police Crime Laboratory?
A forensic scientist 2 has been at the lab for over a year and can do casework.
Now, just in general terms, what does the trace unit do or examine within the State Police Crime Laboratory?
I'm a part of the trace, arson, and explosives unit. So we analyze a wide range of pieces of evidence. So there's trace covers a lot of small things. So paint, fibers, glass, gunshot primer residue, physical matches. Arson covers fire debris evidence, and explosives covers explosives.
Now, specifically with reference to physical match analysis, can you explain to the jury, just in general terms at first, how is that analysis performed?
So physical match analysis is piecing broken things together to see if they were at once a single item.
Okay, before she gets going, I'm going to make sure I'll share it in this one. It's in the other one. Where is it? What day? Not that day. Not that day. So she's the one, and who, where was it? Wasn't it just recent? Like, wasn't it like just the other day? Plastic, there's the plastic. So the pieces of glass that she put together and stuff, they had, oh, here it is. Okay. I'm going to add this to, I put it on the spreadsheet from the other day because we talked about the pieces of glass, but she's the one who compared them. So I'm going to put it in today's part of the spreadsheet too, so you can look at it. But this is, Ashley Vallier's the one who compared the pieces of the glass that they found at the scene and the ones that were found on the bumper and all of that. And so that's the one that we were talking about the other day where like they were surprised that the ones that were on the bumper didn't match the ones that were on the drinking glass and all that.
Generally, you look at the questioned item first, the item that you don't know specifically where it came from. Look at that. And then you would look at the known item, which is an item with a known source, like specifically like this window or like this vehicle. They're analyzed at separate times. And then if it looks like there could potentially be a physical match, you would analyze them together and see if they have a mechanical fit.
Now, when you retrieve items just in general to do some sort of physical match analysis, where do you get those items from?
We have evidence storage locations at the laboratory.
And how are they typically packaged when you receive them?
They can be packaged in cardboard boxes, brown paper bags, heat sealed plastic bags. It depends on the individual items.
And when you're doing this analysis, as far as the physical match analysis, what do you do to your bench between your examination of separately packaged items?
Before I do any analysis, I bleach my bench, clean my tools, and then put down a fresh sheet of butcher paper.
And why do you do that?
To make sure everything's clean.
Now, again, speaking more in general terms, on what types of evidence can you perform a physical match analysis?
Sorry, can you repeat the question?
Sure. In general terms, with your work within the lab, on what types of items can you perform a physical match analysis?
A lot. Anything that has a broken or irregular edge.
Would that include glass?
Yes.
Would that include plastic?
Yes.
What are some of the other things that would also include?
Any sort of like polymer, metals.
And when you're doing a physical match analysis, what instruments do you utilize in the course of that analysis?
Generally, I'll use a stereo zoom microscope, depending on the.
I'm going to put this at 1.25 speed so we can catch up because we had paused to go over the DNA stuff. And while they're doing this, plus this is really technical and it's fine.
The size of the items compared, I can use other microscopes as well.
Now, what is a stereo zoom microscope?
A stereo zoom microscope is a microscope that's mounted on a stand. So it gives a wider range of view that you can look at larger items.
And how are you using that specifically in your physical match analysis of, let's say, items of plastic?
I'll use it to look at the edges and see if there's any like defining characteristics along those broken edges.
Now, as you're going through your analysis, do you document your work as you go?
I do.
And how do you do that?
With handwritten notes and with photos.
Now, at some point, were you assigned to perform some work on lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes.
And what type of work were you assigned to do in this case?
I was asked to do physical match analysis, and then later on, I was asked to look at, do some trace recovery, look at some debris.
Starting with the physical match analysis, how many different items approximately were you asked to look at?
Over 10.
Several, fair to say?
Yes.
Okay. And how were each of those items packaged when you received them?
So the questioned items were packaged first in a large paper bag, and then each item was individually packaged in a smaller brown paper bag within that container.
Again, just in general terms, because you've used it a couple times. When you say questioned item versus known item, as it pertains to this analysis in this case, what were the questioned items generally, and what was the known item?
The questioned items were items labeled as coming from a road, and the known item was labeled as coming from a taillight from a vehicle.
Now, in this case, did you perform your physical match analysis in the same manner that you've previously described based on your education, training, and experience within the lab?
Yes.
Now, initially, you had examined some various plastic and glass items, and there was a drinking straw in there as well, correct?
Yes.
And specifically, as far as the item numbers that you looked at in this physical match analysis, could you provide the jury with a list of just the item numbers first to start with?
May
Your
I?
Honor.
Have your report with you, Ms. Willett?
I do.
Is there any objection to using the report?
No objection at all.
So feel free to use it.
Thank you, Your Honor.
So the questioned items labeled as coming from the road were item 7-5, item 7-6, 7-8, 7-9, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, 7-16, and 7-19. And the known item labeled coming from the passenger side taillight is item 3-1.
Now, Ms. Vallier, within those specific item numbers of how things are labeled at your lab, if there are different pieces associated with the same item, how is it that you label those specifically in this physical match analysis here?
So some of the items had multiple pieces within that item. So I labeled them A, B, C, etc., depending on how many pieces there were.
Now, if you could, please explain to the jury just, again, the process that you followed in your examination of each of those items.
So first I looked at the questioned items, the items labeled as coming from the road. I documented the overall package because they were all packaged in the same container, the same brown paper bag. Documented that individually inside of it, there were a bunch of individual brown paper bags. Documented that, and I went one at a time through them, opening each paper bag, taking written notes, taking photos of the items inside. Within each item, I looked to see if any of those pieces fit together. And I cleaned my bench in between the items.
Your Honor, may I approach?
Yes.
And Your Honor, so of course, I've shown Mr. Yannetti all the photos in advance.
Okay. Is there an objection to any of them,
There's
Mr.
no
Mayor?
objection, Your Honor.
All right, so why don't we just go ahead and mark them all as evidence?
Your Honor, if I could, I was going to take them item by item.
Okay. Okay.
Mixed Vallier, I'm showing you 4 photographs. You recognize those?
I do.
What do you recognize those to be?
These are photos I took of item 3-1.
Again, what was the description associated with item 3-1?
Passenger side taillight.
And was that description further give sort of a specific vehicle or license plate associated with the vehicle that the taillight came?
It does. Massachusetts 3GC684.
Your Honor, the Commonwealth will seek to introduce in a minute the next exhibit A and D.
Right, those are coming. That's why I wanted to just mark them all because they're all coming.
That's fine. If the court prefers, I can provide them.
Exhibits 170A through 170D.
Can I approach with the remainder, Your Honor?
Yes. If you have them in sections, we can do that.
This way, I'm showing you 2 more photographs. Just ask if you recognize those.
I do.
And what do you recognize those?
Photos I took of item 7-5.
And again, from your report, what was the description in reference to item 7-1?
Yeah.
Thank you. You're fine. It's just
Yes. Piece of plastic, red, recovered from 34 Fairview Road.
And Your Honor, the Commonwealth will seek to introduce in a minute the next exhibit A and D.
Okay.
171A and B.
My apologies, Your Honor. With the court's permission, may I publish some of those?
Yes.
photos here? Ms. Gilman, if I could first ask for photograph 2122. And Ms. Vallier, what's up on the screen? That is the bag associated with the passenger side taillight or the known item, correct?
Correct.
And Ms. Gilman, if I could have photograph 2125. And Ms. Gilman, if you could just enlarge a little bit towards the bottom where the ruler is. Now, Ms. Vallier, what's up on the screen now as far as the sort of notations there? Who made those?
I did.
And how do you know that you were the one who made those?
That's my handwriting, and those are my initials.
So the AMV is for your name, correct?
Yes.
And with respect to each of the items that you photographed, you had photographs that were taken of sort of what was in the evidence bag in total, displayed on your table that you would clean with the solution and everything else, correct?
Yes.
And Ms. Gilman, if you could just zoom out a little bit to show the item. And again, what's up on the screen, that is item 3-1, the known item as far as the taillight from the defendant's vehicle.
Yes.
And Ms. Gilman, if I could have 2126. And Ms. Vallier, if you could just describe for the jury, what are we looking at in this photograph?
Those are the same items, just turned over.
And lastly, for this set, Ms. Gilman, if I could have 2135. And again, same item as far as 3-1, the taillight taken from the defendant's vehicle.
Yes.
Ms. Gilman, if I could ask for photograph 1905. And Ms. Vallier, as far as with each of these items, you take photographs when they're inside the bag and then once you take them out of the bag, correct?
Yes.
And Ms. Gilman, if I could have photograph 1908. And what are we looking at in this photograph?
The contents of item 7-5.
May I approach again, Your Honor?
Yes.
two more photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-6.
That's one of the bag and then one when the item is taken out of the bag. Is that correct?
Yes.
And what was the description for item 7-6?
Piece of plastic, clear, recovered from 34 Fairview Road.
Okay, appreciate those. I'll call up to introduce in a minute the next exhibit, A and B.
172 A and B.
With the court's permission, may I publish those to the jury?
Yes.
Ms. Gilman, if I could have photograph 1921 and then photograph 1924. And what's depicted up on the screen is that what you just have before you as the photograph that you took of item 7-6 recovered from 34 Fairview Road.
Yes.
Thank you. May I approach the witness again, Your Honor?
Yes.
Two other photographs, review those. Can you recognize those?
I do.
What do you recognize as?
Photos I took of item 7-8.
And one of the bag and then one of the items removed from the bag, is that correct?
Yes.
And what is the description associated with item 7-8?
Piece of plastic, red and clear, recovered from 34 Fairview Road.
Almost seek to introduce in a minute the next exhibit, A and B. And Your Honor, with the court's permission, if I could publish those to the jury.
Yes.
Exhibits 173 A and B.
Ms. Gilman, if I could have photograph 1931 and then 1934. And Ms. Gilman, if you could zoom in just a little on those items, please. And Ms. Vallier, again, what are we looking at in this photograph of item 7-? What are we looking at again in this photograph? Excuse me.
Photos of item 7-8.
May I approach the witness again, Your Honor?
Yes.
Two other photographs. Those. And you recognize those?
I do.
Or will you recognize those?
Photos of item 7-9 and 7-19.
And as far as the first photograph, as far as the bag, and then second with the items taken out of the bag, is that correct?
Yes.
So 7-9 and 7-19 were contained in the same bag.
They were. I then separated them into two separate packages.
And as far as 7-9 and 7-19, respectively, if you could tell the jury what was the description for each of those items.
Item 7-9 was pieces of glass recovered from 34 Fairview Road. Item 7-19 is trace item, black straw, recovered from 34 Fairview Road.
Your Honor, will seek to introduce in the minutes the next exhibit, A and B. May I publish, Your Honor?
Hold on.
Oh, forgive me.
174A and 174B.
Now you can publish.
My apologies. Ms. Gilman, if I could have 1958, please. And then 1962. And again, Ms. Vallier, what are we looking at in this photograph?
The contents of that bag, item 7-9, item 7-19.
May I approach again, Your Honor?
Yes.
Two other photographs, do you recognize those?
I do.
And what do you recognize as?
Photos of item 7-10.
And again, one of the bag and one of the contents of the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description for item 7-10.
Piece of plastic, red, recovered from 34 Fairview Road.
I'm going to introduce in a minute the next exhibit, A and B.
Exhibits 175A and B.
May I publish that for the jury, Your Honor?
Yes.
Ms. Gilman, if I could have 1952 and 1956. And again, Ms. Vallier, what are we looking at in this photograph?
Photo of item 7-10.
Thank you. Gilman, you can take that down. May I approach the witness, Your Honor?
Yes.
And two other photographs, do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-11.
And again, one photo of the bag and one photo of the items outside the bag.
Yes.
And again, if you could, please tell the jury what the description is associated with item 7-11.
Piece of plastic, 6, red, clear, and black, recovered from 34 Fairview Road.
Almost introduce in a minute as the next exhibit, A and B.
Exhibits 176A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, 1979 and 1982. Again, Ms. Vallier, I'm sorry, Ms. Gilman, if you could zoom in just a little on the items themselves. And Ms. Vallier, what are we looking at in this photograph?
Photo of item 7-11.
These are photos, again, that you took in the lab during the course of your comparative or physical match analysis, correct?
Yes.
May I approach again, Your Honor?
Yes.
Two other photos, if you could look at those. Do you recognize those?
I do.
What do you recognize those?
Photos I took of item 7-12.
And again, photograph of the bag, photograph of the items outside of the bag.
Yes.
If you could, please tell the jury what's the description of item 7-12.
Trace item 14 glass and clear plastic recovered from 34 Fairview Road.
Now, the Commonwealth seek to introduce in the minutes the next
Okay.
exhibit.
Exhibit 177A and 177B.
Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 2015 and 2018. And again, Ms. Gilman, if you could just zoom in a little on the items. Thank you. And Ms. Vallier, again, what can you describe what's depicted up on the screen?
It's a photo I took of item 7-12.
Your Honor, may I approach?
Yes.
These two other photographs, do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-13.
And again, one of the bag and then one with the items removed from the bag.
Yes.
And if you could, please tell the jury what is the description for item 7-13.
Piece of plastic, red and black, recovered from 34 Fairview Road.
I'll look to seek to introduce in the next exhibit A.
Exhibit 178A and 178B.
Your Honor, may I publish?
Yes.
Ms. Gilman, 1997 and 2000. And again, Ms. Gilman, if you could, please zoom in on the items. Thank you. And Ms. Vallier, directing your attention to the screen, can you describe to the jury what is depicted on the screen now?
A photo I took of item 7-13.
May I approach the witness, Your Honor?
Yes.
Two other photos. Do you recognize those?
I do.
What do you recognize that?
Photos I took of item 7-14.
And again, one of the bag and one of the items removed from the bag.
Yes.
And $2000. And again, Ms. Gilman, if you could, please zoom in on the items. Thank you. And Ms. Vallier, directing your attention to the screen, can you describe? And 2000. And again, Ms. Gilman, if you could, please zoom in on the items. Thank you. And Ms. Vallier, directing your attention to the screen, can you describe to the jury what is depicted on the screen now?
A photo I took of item 7-13.
May I approach the witness, Your Honor?
Yes.
Two other photos. Do you recognize those?
I do.
What do you recognize that?
Photos I took of item 7-14.
And again, one of the bag and one of the items removed from the bag.
Yes.
And again, can you please tell the jury what the description is associated with item 7-14?
Pieces of glass recovered from 34 Fairview Road.
I'll seek to introduce the next exhibit, A and B.
Exhibit 179A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2009 and 2012. And again, Ms. Gilman, if you could zoom in on the item. And Ms. Vallier, as far as what's depicted on the screen, again, if you could describe for the jury what that is.
A photo of item 7-14.
May I approach the witness again, Your Honor?
Yes.
other photographs, if you could recognize those.
I do.
And what do you recognize that?
Photos of item 7-15.
Again, one of the bag and one of the items taken from the bag, correct?
Yes.
And if you could, please tell the jury what is the description associated with item 7-15.
Piece of plastic, 3 clear and 5 red, recovered from 34 Fairview Road.
I'll proceed to introduce in a minute as the next exhibit, A and B.
180A and 180B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2072.
Yes.
Yes.
And 2077, please. Again, if you could zoom just a little as far as the items are concerned. And Mr. Vallier, what are we looking at in this photograph?
Item 7-15.
May I approach again, Your Honor?
Yes.
Other photographs, do you recognize that?
I do.
What do you recognize that?
Photos I took of item 7-16.
And again, one of the bag and then one of the contents from the bag, is that correct?
Yes.
If you could, please tell the jury what was the description associated with item 7-16.
Piece of plastic, red and clear, recovered from 34 Fairview Road.
I'm all to seek to introduce in the minutes next exhibit, A and B.
Exhibit 181A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2036 and 2040. And Ms. Gilman, if you could zoom in just a little. Thank you very much. And Mr. Vallier, if you could, please describe to the jury what we're looking at in this particular photograph.
This is item 7-16.
Ms. Gilman, you can take that down. Now, with respect to each of these items that you examined in your physical match analysis, again, as far as the process is concerned, with the questioned items, what are you doing with reference to each of those questioned items first?
First, I document them, as you've seen. I'll see if any of those within the item have a physical match with each other. And then I'll package that away and look at all the questioned items before I compare inter-questioned items to see if there are any physical matches in between all the 7- items.
And as far as your notes are concerned, what is it that you're noting in reference to each of those items, as far as what characteristics of the item are you taking note of?
I'll note the size, the color, and the material.
And what, if any, measurements do you take of each of those respective items as well?
I'll take the length and width of each item.
Now, with respect, starting with item 3-1, the passenger side taillight from the defendant's vehicle, sort of internally within that item 3-1, what did you conclude as far as your physical match analysis within that item alone?
Within item 3-1, I believe 4 of the pieces fit together.
And Your Honor, if the witness may refer to her note
Yes.
as to, thank you.
Yes, 4 of the pieces fit together within item 3-1.
And which 4 of the pieces?
Pieces A, B, D, and F.
And as far as the labeling of those pieces of an individual item, let's just start with item 3-1. A, B, D, and F, how are they labeled, and how do you sort of physically label those items?
We have a label maker in the lab, so I'll print out the case number, the item number, and then A, B, C, and my initials, and that goes physically on each of those items, or all of those pieces.
So if any of those items had a sticker on it with a letter or something associated with that, that would be something that you did during the course of your physical match analysis, correct?
Yes.
Now, if I could turn your attention to item 7-5, piece of plastic, red, recovered from 34 Fairview Road. What did you conclude as far as your physical match analysis just within that single item?
There was no physical match noted among those 3 pieces of apparent plastic.
And when you say no physical match found from the different pieces within that item, what does that mean?
the broken edges of each piece did not align.
So the broken edges of the individual pieces within item 7-5 did not fit together with the broken edges of pieces within item 7-5, correct?
Yes.
Now, with respect to item 7-6, a clear piece of plastic recovered from 34 Fairview Road, what did you conclude based on your physical match analysis just pertaining to that item 7-6?
So this item was 2 pieces of colorless apparent plastic, and there was no physical match noted between those two pieces.
Now, with reference to item 7-8, red and clear plastic recovered from 34 Fairview Road, what did you conclude in regard to your physical match analysis just with the pieces contained within item 7-8?
So there were 14 pieces. Pieces C and D fit together, and pieces E and F fit together.
And when you say fit together, is there a term of art used within your field called a mechanical fit?
Yes.
And can you explain to the jury what you understand that term to mean as far as what is a mechanical fit?
So a mechanical fit and a physical match are the same thing. It's when the broken edges align together to show that they were once a single item.
Now, if I could turn your attention to item 7-9, pieces of glass recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis of just the individual pieces contained within item 7-9?
So this item had 3 pieces, and no physical match was found between those.
Turning your attention to item 7-10, red pieces of plastic recovered from 34 Fairview Road. What were you able, that is a single item, is that correct?
Correct.
So no physical match because there's nothing to match, it's just one piece, correct?
Correct.
Okay. And turning your attention to item 7-11, identified as 6 red, clear, and black pieces of plastic recovered from 34 Fairview Road. What did you conclude in regard to your physical match analysis just within those pieces contained within 7-11?
So that item had 6 pieces, and there was no physical match noted among those 6.
Now, turning your attention to item 7-12, which was identified as 14 pieces of glass and clear plastic recovered from 34 Fairview Road. Again, what did you conclude from your physical match analysis just from the various pieces contained within item 7-12?
So there were 14 pieces overall. Pieces B, C, D, F, and K fit together mechanically as one unit. And then pieces E and I fit together mechanically as one unit. And pieces M and N fit together mechanically as one unit.
Now, through your examination of these pieces in particular and other pieces as well, did you note any debris contained on the pieces that you located?
Yes.
And can you say anything as far as what that debris was, or was there any analysis done of that debris specifically?
I just note that there was debris present, and I package it into a tin that's retained with the original packaging.
Now, turning your attention to item 7-13, that was a piece of plastic, red and black, recovered from 34 Fairview Road. Is that correct?
Yes.
And again, just with respect to your physical match analysis of the various pieces of 7-13, what did you conclude?
So that item had 3 pieces, and there was no physical match noted among those 3.
And again, with reference to item 7-14, piece of glass recovered from 34 Fairview Road, that was again a single item, correct?
A single piece, yes.
So I'll turn your attention to item 7-15, 3 clear and 5 red pieces of plastic recovered from 34 Fairview Road. Is that correct?
Yes.
And what were you able to conclude from your physical match analysis, again, just from the various pieces contained within item 7-15?
So there were 8 pieces in this one. Pieces F and H fit together mechanically.
Turning your attention to, lastly, for this purpose, item 7-16, a piece of plastic, red and clear, recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis just contained within the pieces of that single item, 7-16?
So that item had 7 pieces. Pieces A, C, and D fit together mechanically.
Now, Ms. Vallier, once you had examined each of those pieces individually, what did you do next in your analysis?
Next, I compared all of the inter-questioned, these items 7-5 to 7-16. I compared them to see if there was a mechanical fit amongst those, between those items.
Mr. Lally, is this a good place for our break?
It's perfect. Yes, Your Honor.
All right, jurors, we'll take our morning break. We'll see that here in about 15 minutes. Thanks for letting you can walk out break.
Mr. President, jury.
And can I see counsel for a minute, please?
I hate it when they make me pay attention on a Friday. All right, let's skip ahead.
Completely around.
Duh. Too far. Too far. Too far.
All right, Mr. Lessie, I'll hear you.
Oh boy.
You are unmuted.
Oh boy. What are we arguing?
Thank you, Your Honor. Yesterday, Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess that the defense received on May 11th. And what I wanted to do, Your Honor, is briefly provide the information Your Honor asked for yesterday, which was how much time we might need under various circumstances. And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so. So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue. And so with regard to the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need. I again urge the court to reject it substantively, because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with regard to observing a vehicle at 12:45 a.m. We, and that's a significant point. I know I don't need to elucidate for Your Honor. It goes, all of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. It just never, no collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information, and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is we have on May 11th, Mr. Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we crossed, we strategized with regard to, but also my decision to not even cross Trooper Garino, because Trooper Garino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that. We have Mr. Whiffen, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had, and I cross-examined Mr. Whiffen extensively with regard to that timeline. There were several defense strategies and effectuations of strategies based upon that timing. So with regard to the substance, Your Honor, and there's more, but I think that's a fair representation. It innervates our entire defense. The question now of Your Honor of how much time it will take the defense to react to Mr. Burgess, I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation in terms of cross-examination. So we would have to, and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared that are based upon that timeline. So it is a very significant point. And to the extent that the Commonwealth tries to argue, well, you know, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range, 38 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked yesterday. Again, I urge that it just be rejected and we keep this trial moving in its current pace. To the extent that that does not occur, and again, we urge that it be rejected, the report, because it's a Rule 14 violation, there is no remedy for the defense. However, to the extent, and given Your Honor nonetheless asked me for an answer in time, we would need 4 days to be able to address it. We will not ever be able to recover strategically or substantively from it, given all that's been presented to the jury. And it will be very difficult to figure out how we're going to go present a defense after we've already presented to the jury our defense in our cross-examination. It's not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them and eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as Arca, but DeSogra and Gaffney and other types of witnesses that we have in that regard. So Your Honor, respectfully, that is my response.
All right, does the Commonwealth want to be heard?
Yeah.
Okay.
Hey, block him. Block him.
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact would be. This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided. The Commonwealth has always provided the data, which they have, and they hadn't a chance to analyze.
Oh, Lord.
And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12:31:43, has never changed. Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believe that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's ways data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked at the variance at the time of a 3-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the telestream, and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody. They point to Jen McCabe's text message where she said she thought she saw a motor vehicle out front that evening at 12:45.
Hold on. He's sitting here saying, oh, just because their expert made a mistake, that's not our fault. Bro, it's your expert that you want to change this. We're here because of you. This is your dude. We're here listening to you whine because this is your dude who wants to change this.
That is not consistent with the Commonwealth timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorda. And so because this is inconvenient for the defense, and because it further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance.
No, it's not. No, it's not. Your dude said he was changing it to align it with Whiffen. No, it's not. I can't stand this dude.
Variance. There's nothing new here. Nothing has changed.
Okay, well then take your stupid new report and
Go right ahead, Mr. Leslie. The only question I had for you yesterday, for you to respond to today, was the time, so I gave you more leeway.
And
So
you're giving me more leeway, and I appreciate it.
go right ahead.
So 2 items, Your Honor. As I alluded to yesterday, and it's been a point that Mr. Brennan just made. We believe strongly, Your Honor, that at a minimum there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline. In his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report, is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday said, we were surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, and he made it yesterday and I corrected it, he said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done. Final point is this. There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. there's not only the question of should this be allowed at all, there's not only the question of how much time the defense will need, but there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the aperture gets to wait, they come on, and then the aperture gets to come on yet again. We would urge.
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr.
I would
Brennan?
appreciate the
I'm
clarification.
not sure what he's saying, so. I
It
don't
sounds
know what
like
he's talking about.
DeBrosia or whatever,
His name is DeSoder, yes.
DeSoder, you're suggesting that the Commonwealth suggested yesterday that he testifies first and then the aperture witnesses?
What I understood was going to happen is Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st or whatever the date was.
No, that's
And
not.
then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr.
Yeah,
Brennan?
they want him to come and then
That's the
come back.
conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So I did, just
Wants
so
to come
I'm
and come
clear,
back.
what is it that the rebuttal?
Mr. Brennan, all right, this is separate, and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Regarding Mr. Burgess or Mr. Welcher?
Which, Dr. Welcher?
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which address all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments, Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal, address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how I did also, but the question is now with the Burgess changing of the clock drift, how many times is the Commonwealth proposing that Dr. Welcher gets to come in and talk about that? Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that. All right, so I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same. He's always said there's
Why
a
is there a new
variance. He's
report?
been looking into the variance for a long time, and now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been. Other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever. None.
Does the Commonwealth oppose a voir dire just on that one issue?
Yes, because it's suggesting that there's a good faith basis for it. Nothing has, Ian Whiffin's report was available to the defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between Dr. Welcher, Ian Whiffin, Jessica Hyde, or Shannon Burgess. They are just saying things without a good faith basis. In the reports, show us where something has changed.
Your Honor, to inform you, Your Honor, we would like to print the page in the clock adjustment because what Mr.
So,
Brennan says is
yes,
correct.
and I'm happy to any information.
Thank you.
All right,
Change.
20 minutes.
No,
Thank you.
All rise for the court, please.
Mm. What are we thinking? How are we feeling? Mm. Well, they are talking about the arguments that they made yesterday. So Brennan keeps saying, nothing has changed. Nothing has changed, except for this new report we want to give you. Nothing has changed. Their expert was wrong, and we figured it out because we're so amazing. They're talking about the clock variance. That's something that, yes, that's something that both sides have talked about the entire time. This is not new information. They have had like a clock drift or clock variance or whatever they want to call it at different times. So Alessi is saying that, well, first of all, there's a few problems. So he's talking about the sequestration order. So he's like, okay, so your guy is like saying that he's changing the time of when they're saying that this happened to align with Whiffin's testimony. So how do they know Whiffin's testimony? Because they're supposed to be sequestered, and we want to be able to ask them about that. These people give me a headache. And then Brennan's trying to say that the reason that this time on this report that he wants to give, that he's given this new report with this new time, is because he found an issue with the time variance that their expert was talking about. And Alessi's like, that's not possible because he can't say that this is a time based on our expert. Our expert was doing this based on the time that he gave. So it's like, if our guy's saying, hey, here's my rebuttal to what he said, then you can't come to that rebuttal and be like, oh, he was wrong, so here, I'm changing this. He's rebutting what you said. He's arguing what you said. So then you can't say all of a sudden, oh gosh, he gives me headaches. Especially when it's been technical stuff all morning and I've had to take notes and haven't even been able to have fun with y'all. And then he argues. It gives me a headache. And she's going to allow it. She's going to allow it. And she shouldn't. She shouldn't, but she will. The thing that frustrates me the most, two things. One, how dirty Brennan plays. He's slimy. He's dirty. I don't like him. He comes across to me. These are all my opinions, just my opinions. He comes across to me as very unethical, because you don't try to prosecute somebody using the back door. Everything should be on the up and up. And when you're constantly trying to pull some slick stuff, that's a problem. He's a problem. And that's why Alessi is telling him, or telling the judge, like, there is no remedy for this. Like, you're asking how much time we would need to adjust everything moving forward to go over what he's saying and to figure out how to prepare all the stuff we have coming up. But we can't go back and change anything. We can't go back and now cross-examine anybody differently based on him turning in a new report. It's wild to me. When are they coming back? I'm not really sure, honestly. I have not, I did not write down when the break started this time. I normally write it all down to keep up with chapters so I can put chapters at the end for y'all to make it easier for you. But doing all this stuff, having to keep up with 7-5-9- or blah, 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 blah. My brain is working harder today than I wanted it to for a Friday. How do you think this trial is going compared to the first one so far? I think that I have a few thoughts on that. I think that it is going better for the defense in a lot of ways because Brennan has tried to keep a lot of the key witnesses out so that the defense isn't able to cross-examine them. But also think about how convoluted the prosecution's case was last time. And by keeping so many people out and trying to present the evidence he has presented, it has really showcased how bad the evidence is. And I think that there are so many things that have been able to be picked apart from their evidence that they've presented. So I think it's actually going better for the defense. And I think that Brennan is spiraling out of control because of that, honestly. That's just what I think. I wonder what the jury is thinking. What are we thinking? How are we feeling? It's like, okay, this is, I also am spiraling out of control. Yes, same. The thing is, it's like one of the biggest points for the defense has been that the Commonwealth's timeline doesn't make sense, right? So it's like you keep changing your timeline because your timeline doesn't work. And you keep saying this and this and this, happened at this time. And then your next expert is like coming and giving stuff that's totally different. Like they keep changing, like it's like moving the goalpost, right? And that has been a huge crutch in their case, and the defense has been able to point that out. So now it's like they're like, oh, busted. Now let me change it and then blame it on the defense being wrong about stuff. But you can't now come in and fix a big part of the holes in your case while we're almost at the end of trial and just be like, hey, I'm going to come in and fix all this stuff. And it should be allowed. And as much as Brennan gets on his stupid Weasley soapbox and preaches about trial by ambush and Rule 14, violations, and like, he gets so dramatic with it. Oh gosh, he's so dramatic. I too can be dramatic, but nothing like that. He's dramatic in a way that's like, he pretends to be morally outraged. It's like Julie. Never mind. He pretends to be morally outraged. And that drives me nuts. The worst part about this is that the prosecutor seeks a victory over justice. That's the big thing. It's like he's not, and that's one of the things, like, I hold prosecutors to such a higher standard because it's like, you're supposed to be seeking the truth. You're supposed to be on the up and up. We should be able to trust you. You are representing the people. You have moral obligations. Defense attorneys represent their client. Prosecutors represent the people and truth and justice. And he doesn't do a very good job of that. He just wants to win. How are we feeling? Ready to take a road trip from North Carolina. My 15-year-old, 12-year-old grands even know this ain't right just by listening to trial without me saying anything. I know. I know. The entire point of this case has been lost in all the drama. I agree. Hank is trying this case as if he's sitting at the defense table. He has burden shifted this entire trial. It's disgusting that he has gotten away with it till now. I agree, and I've said this from the beginning, that he prosecutes this case as if he's a defense attorney, and he is slimy, and I don't like him. These are just my opinions. I am very opinionated. If you think he's great, everybody needs somebody that likes them, right? I need a goat. But think about it like this too. It's like, look at the difference in how decisions are being made for the defense versus how they're being made for the prosecution. Think about what all is like allowed and not allowed. You know what's funny? Yes, DePietro, or whatever his name is, loves him. I am not surprised. Do you know that I thought that was a I thought it was a parody account. I was like, oh, this guy's so funny. I thought it was a parody account, but it's not. He's like real life. He's wonder if first trial jurors watching and their thoughts. That would be very interesting to know. I would love to know that. I'm also pretty bitter that they made me pay attention all morning and take notes. And now hold on. Also, I want to try to change this real quick while we're at break because I'm having issues with studio. Live. Only fan. I think she's going to allow it. And I don't think she should, but I think she will. Fixed it. Yay, that makes my life so much easier. There we go. I was having issues with the stream and now I fixed it because I'm a genius. Let's see what y'all are saying before I have to start taking boring notes again. NBC 10 has Ronnie on all the time. Yeah. Ronnie has some interesting things to say, which is funny because you can tell that Hank has used Ronnie's feedback in how he prepared things, because when Ronnie said something about, like some of the jurors thinking that Jen McCabe was just a normal mom, she comes out and she's like, I'm just a normal mom. And then, the things that he was like, yeah, some of the jurors were like, maybe, because she was just drunk and there, she had to have done it. And so he's focusing on like, she was drunk and there, so she had to have done it. So you can tell that he's like, based on her ruling so far, I agree. She will allow it. Can they ask for a mistrial? Yes, but will it be granted? I doubt it. I'm going to have to go back and watch the first few hours later. I'm so lost. It was a lot of note taking. I put a graphic that summed it all up. Like, this is one of those things, like that first couple hours was like, this could have been an email. Yeah, Ronnie was on the first jury. Oops. Did the second jury ever hear about the phones that got thrown out at the military base? No, because Brennan is trying to keep all of that stuff away from them. And so he did not call, he has not called Higgins, because, the defense can only bring in evidence through certain witnesses. You have to have firsthand knowledge of what you're testifying about. So you can only bring in information through witnesses who have firsthand knowledge of it. Question. So the sequestration rule, obvious violation by DA's witness, new revisions is going to be overlooked by the judge. Brennan is saying that it's based on reports, not on testimony. So the evidence logs that were for the taillight pieces 14-5 through 15 or whatever, they skipped 18. For why? Let me see if I know that. We don't have 7, 17, or 18. 7, 17, or 18. So they were probably something else. So instead of being plastic taillight, they were probably something else. I'm not sure what they were. Maybe, let me see. 17, 18. See, 7-12 is, and 7-14 is glass from the yard. Yeah, so it was probably just, it was something other than plastic taillight pieces. They are not back from break yet. You're famous. They're definitely having ex parte communication. That nod they gave each other during the arc. Oh yeah, you're talking about Cranky Hanky and Auntie Bev. You can't make this stuff up that's going on in this courtroom. It's affecting real people's lives. It's not pretend. This is reality. I think that that's one of the things that is just so wild to me about all of this is that, like, this is really shady stuff that's happening. And it, like, this is, you know, somebody's life on the line. Wonder who that Watson guy was. I have a lot of questions about that. I want to know if there's only 2 Watsons that I saw that are employed with Massachusetts State Police, and neither of them look like that. And also, why was it like Trooper Connor and Trooper Keefe? And why did they have it labeled as Proctor and Keefe? And why? Oh, I have so many questions. Well, Best Buy's open the door for appeal. I mean, it depends. It's like the appeals process is it's a uphill battle. You just did a Watson deep dive. I haven't had time because I've been taking notes on evidence numbers. They didn't say Watson's first name. And the only Watsons that I found on Massachusetts State Police were, I have to go back and look. I think it was like a Brian was one of them, of course, because they're all Brians. And I think the other one's like Sam or something. I don't know. Yeah, there's a Trooper Brian Watson. It's all Brian's. Yeah, me too, Rand. The file name was Proctor and Keefe, and then I went back and listened to what she said about the log, and she said Mr. Keefe and Mr. Connor. Yeah, which is why we were all like, Mr. Keefe and Mr. Connor? You mean Mr. Connor Keefe? What? Will the defense call Higgins? Maybe. It's a risk though, right? Because I mean, think about it. If they call him right now, he's like that shady figure that, you know, they've done a really good job at presenting him in a certain way. If they call him, it gives him the chance to explain himself. And then you risk the jurors, you know, believing what he says. But if you call him, it does open it up to be able to put in more information about him. For example, disposing of his phone at a military base without backing it up. Okay, but when can we see the log? I don't know. I need to do a FOIA request for that because I have questions. Does Karen get to testify at all? She can take the stand if she wants to. Yeah, that's something that after the Commonwealth has rested their case, the defense gets to put on their case. And if she wants to testify, she can. If she does, you know, of course, that opens her up for cross-examination. And she does about as good of fixing her face as I do of fixing mine. So if Brennan gets up there, he knows that. Because he tries to tick her off. Like, have you know, like he'll do that little stare down thing with her, and he'll make a point to do it to, you know. So I don't think she should. She can't fix her face. I can't either. Brennan cross-examining her would be like Brennan cross-examining me. Could you imagine me trying to control my snark with Brennan up on his little soapbox? What military base did he throw his phone away at? I don't know. He said he was just cutting through, which is funny because I was talking to my husband about that, and my husband was like, you know, at military bases, we like that trash just goes to a regular dump too. It's really funny. It would be the ultimate snark fest, yeah. I keep hearing different things. Is Proctor testifying? The Commonwealth said that they did not intend to call him. I don't know if that is still the case. And I don't know if, you know, the defense is going to call him. So I guess it just depends. The defense, if they call him, so if the prosecution had called him, the defense would be a lot more open on how they can question him, because on cross-examination, you have more of an open way that you can ask questions and stuff like that. But on direct questioning, it's a little bit more, well, I say on direct questioning, it's stricter, not with Brennan. He just does what he wants. But normally it's a little bit more regulated in how you can do it and what you can do it. But he would be, should be a hostile witness, which means if they're a hostile witness, hostile doesn't mean just like hostile, like I get hostile when I'm talking about him. It's different kind of hostile. Hostile witness in that case is like somebody like it's somebody that one party is calling that's like a opposite, from the opposite side or whatever. But the new revisions on the paper is quoted to align with Whiffins. That's exactly what Alessi said. He said, quote, didn't he say quote? Am I making that up? I'm pretty sure he said quote. However it was, he said it. He either said quote or he said that he said it was to align with, however he said it, he was saying like, that's what your dude said. Your dude said he's aligning with Whiffin. We are caught up to live. We're just waiting on the OnlyFan. The OnlyFan is like over here on my head now, and I don't know why. Like, it looks like, hold on, wait. It kind of looks like You remember those like little party hats that like spin around or whatever? That's what it looks like. Or like a fancy Kentucky Derby hat with a fancy little spinner. I know I should get some sleep. I was up most of the night. Yeah, opposite side, and they're not being cooperative with questioning. Is hostile witness, which means you can ask them leading questions. Lieutenant Charles Ray wellness dash cam showed the taillight virtually intact until Officer Zachary squirrel photographed it at Sallyport where it had been stripped. Yeah, and the same thing with the when she pulls out of the driveway in that ring cam, you can see that there's a hole in it, but then you can see there's so much red, and then they show it at the Sallyport, and there's that one little piece of red just buried in the corner. Goodness. Bless you. Yeah, propeller. You know those little hats with the propellers? Thank you. He lets me be me. They're on brunch and recess. Oh gosh, now we're going to be back and I have to take notes again. Ugh.
Court is in session, please be seated.
Thanks, Chrissy.
I can't talk to y'all as much when I'm doing this because I have to take notes. Otherwise, I'm going to have to go back and watch the entire
All right,
testimony again.
Mix Vallier, I'm going to ask you that you speak right into your microphone when you answer, if you could, please.
Okay.
Thank you. All right, Mr. Lally, go right ahead.
Thank you, Your Honor. Now, Mix Vallier. We talked about sort of the physical match or mechanical fit analysis that you did with regard to each of the items individually, correct?
Yes.
And can you explain for the jury the process that you undertook in your physical match analysis between different item numbers?
So between different items, amongst the questioned ones, I only compared the pieces that were large enough to have a label on them. Some pieces were quite small. I utilized several benches and divided them up into sections for each item and individually pulled out all of those pieces. And then I had another bench where I did the actual comparison. I started with all the pieces of the same color and looked to see if any of those had potential edges that could match.
Now, with respect to items 715 and 716, did you do a physical match analysis between those two separate items?
May I look at my notes?
Yes.
Okay. Yes.
And what, if any, conclusions did you come to in relation to your physical match analysis between item 715 and item 716?
Two pieces from item 7-15, F and H, fit mechanically with two pieces from item 7-16, F and G.
And what, if any, conclusion were you able to draw with reference to the physical match between pieces from item 715 and pieces from item 716.
Those 4 pieces were at one time together as part of a larger unit.
Now, Ms. Vallier, what physical match analysis did you do with reference to items 7-6 and 7-11?
So one piece from item 7-6, piece B, fit mechanically with one piece from item 7-11, piece D. So those 2 pieces were at one time together as a larger unit.
And Ms. Vallier, with reference to items 7-8, 7-9, and 7-16, what, if any, conclusions were you able to draw from any physical match analysis you did between pieces from those 3 items?
So 2 pieces from item 7-8, pieces C and D, 1 piece from item 7-9, piece A, and 1 piece from 7-16, piece E were found to have a mechanical fit. So those pieces were at one time together as a larger unit.
Lastly, for this section, at some point did you do a physical match analysis for the glass pieces in items 7-12 and 7-14?
Yes.
And what conclusions were you able to draw from your physical match analysis between 7-12 and 7-14?
There was no physical match between the glass pieces from, or parent glass pieces from 7-12 and the glass piece from item 7-14.
Now, Ms. Vallier, are you aware that there was an additional analysis that was done with respect to glass pieces and other glass pieces that you didn't examine in your analysis at your lab?
I know that there was other trace work done. I'm not sure exactly what the work was.
Okay. And do you know who performed that additional trace work?
Christina Hanley.
And who is she to you as far as in reference to your work at the lab?
She's my supervisor.
Now, with regard to each of these items individually, they came as labeled in individual bags as we demonstrated on the screen, correct?
Yes.
Okay. And with respect to those bags, did you note any particular date associated on the front of those bags?
That's documented in my photos.
And all I'm asking here is that with respect to each of those bags of items, whether they be 3-1, 7-4, 7-5 or 6 or 8, many of those bags had different dates on them, correct?
Yes.
Okay. And when you received those items in that bag, you essentially remove the items from those individual bags, place them on the table, and examine them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one date that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
Now, if I could turn your attention to item 3-1. Again, for the jury, what is the physical description associated with item 3-1?
Item passenger side taillight, Massachusetts 3GC684.
Now, did you perform a physical match analysis with pieces from item 3-1, 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16?
I compared them, yes.
And what, if any, conclusions did you come to from your analysis, your physical match analysis between item 3-1 and all of the items beginning with the number 7?
There was a physical match with, do you want me to list?
If you
all
could,
of them?
please.
Okay. So 2 pieces from item 7-5, 4 pieces from item 7-8, 1 piece from item 7-10, 4 pieces from item 7-11, 2 pieces from item 7-12, 2 pieces from item 7-13, 4 pieces from item 7-15, and 4 pieces from item 7-16 were found to fit mechanically with item 3-1.
And what, if any, conclusions were you then able to draw from your physical match analysis between item 3-1 and each of those respective items beginning with the number 7?
Those pieces were once together as part of a larger unit.
May I approach, Your Honor?
Yes.
No.
Where I'm showing you 3 additional photographs. Do you recognize what's depicted in those?
I do.
And what do you recognize those?
This is a comparison between item 3-1 and those pieces from all of the other pieces.
Your Honor, Commonwealth, seek to introduce and admit
Ugh.
as the next exhibit A, B, and C.
Is there any objections to unanimous?
No objection, Your Honor. Thank you.
182, A, and C.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 2096. Ms. Gilman, yes. If you could even zoom in just a little bit more on the item itself. Ms. Vallier, what are we looking at in this photograph?
So those pieces that I labeled from item 7 all of those, they all fit together mechanically into this piece.
And as far as earlier, you were testifying as far as the label maker and the different various pieces that you would label throughout the process of your physical match analysis. Do you see these in this photograph as well?
I do.
And where are they located with reference to the reconstructed piece above?
They're those little white rectangles on the piece.
So what's depicted here is the mechanical fit between items 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16, correct?
Not items 7-8 and 7-14, but the other ones, yes.
And why not those two?
They didn't fit mechanically with the other pieces.
Ms. Gilman, if I could have 2150. And again, if you could just zoom in a little. And Ms. Vallier, what are we looking at in this photograph?
So on the right side was that piece that was just shown. And on the left side is item 3-1.
And lastly, Ms. Gilman, if we could have 2151. Again, if you could zoom in on that item just a little. And Ms. Vallier, what are we looking at in this photograph?
So that's that right piece on top of the tail light from the previous photo.
And is this the mechanical fit that you were testifying about earlier with reference to item 3-1, the tail light housing, and all of the various pieces that were found in 34 Fairview, starting with the number 7?
Yes.
Thank you. Ms. Gilman, you can take that down. Ms. Vallier, lastly, in reference, did you also receive some debris from John O'Keefe's clothing?
Yes.
And Mr. Officer, we can have the lights back on. Thank you very much. And what did you find contained within that debris from John O'Keefe's clothing?
So it was 5 different items. So it was debris collected from, labeled as coming from the clothing. There was mostly debris, some apparent fibers,
Were there any pieces of apparent plastic contained within the debris?
Yes.
Was there dirt contained within the debris?
Yes.
And that debris was labeled as an item 17-18.18. Is that correct?
I believe so.
And what is it that you did with the debris from the gray long sleeve shirt and the orange t-shirt?
So those were all packaged in like glassine folds. And I looked through it and documented it.
When you say you documented it, did you look at it under a microscope?
Yes.
So you did an examination under a microscope, is that correct?
Yes.
And did you measure some of those items contained within the debris?
Yes.
Specifically, did you measure items of apparent clear plastic contained within the debris?
Yes.
And what did you measure those items to be?
The piece of clear apparent plastic was approximately 1/8 inch by 1/16 inch.
And once you had conducted your preliminary analysis of those items, where did those items go?
I did no further examination on this myself. Christina Hanley might have examined some of these further.
Thank you. I have nothing further.
Oh, goodness gracious.
Thank you very much.
Good afternoon.
Good afternoon.
I'd like to first talk fairly briefly about your reconstruction of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1. Am I correct?
Sorry, for which one?
That's the taillight, this 7-3.1. Am I correct?
3-1, I believe.
7-3-1.
The taillight is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yeah. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
How long were you made aware of that?
No.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct? Or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from 1 Meadows Ave in Canton?
No.
Were you ever told about a collision at 1 Meadows Ave in Canton?
Sustained.
In any case, you'll agree with me, there was no glass in that taillight at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no glass as part of the taillight, correct?
I mean, it depends on what you call, like the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass though, correct? Those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've testified to that, correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure of that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Yes.
You never saw that debris inside the clothing, correct?
Correct.
And the pieces of clothing that come in are given evidence numbers when your lab receives them, correct?
Yes.
For instance, the orange t-shirt was given or was named item number 7-17.
Yes.
And the gray long sleeve shirt was item 7-18, correct?
Yes.
And your lab is accredited, correct?
Yes.
There is a complete chain of custody from the moment the clothing was brought to the lab to when the debris was removed from the clothing, ultimately to when you're in court today handling the items, correct?
Chain of custody?
Yes. Our
Who knew?
in-lab chain of custody extends from when we receive it to when the submitting agent, it is returned to the submitting agency.
Okay. And you have complete confidence that the chain of custody at your lab is effective at making sure that the evidence does not get lost or mixed up or contaminated, right?
I mean, chain of custody is meant to track where a piece of evidence is. The evidence unit also does inventories and audits to make sure that things are where they're supposed to be.
And you have confidence in your lab's chain of custody policies and procedures, correct?
Yes.
But you'll agree that your lab cannot control who handled the clothing before it arrived at your lab, correct?
Yes.
There are times in which crime scene technicians or criminalists from your lab actually participate in the search for evidence at a crime scene, do they not?
Some of the people at the lab are crime scene responders, yes.
There are times when they actually take custody of evidence. Again, I'm talking about people from your lab, professionals. They take custody right from the crime scene and transport that evidence to your lab, correct?
Yes.
In those circumstances, your lab would have a complete chain of custody from discovery to seizure to testing or whatever comparison you're doing until you release the items, correct?
Yes, but the electronic chain of custody doesn't start until that item is entered into our LIMS system at the lab.
Right, but when it's entered in, it would be entered in as having been seized by somebody from your lab, correct? In the hypothetical that I'm giving you.
Yeah, there's an evidence submission form that says that this crime scene responder submitted it to the laboratory.
There are other cases, however, when the evidence is brought to your lab by the police, correct?
Yes.
Local departments have access to your lab?
For evidence drop-off, yes.
The state police have access to your lab for evidence drop-off?
Yes.
And in this case, it was not a criminalist or other professional from your lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes. Okay.
Lucy's like, I've had enough of this. She's over there scratching her bowl. I knew she would do this when it got to be around lunchtime. So I have food right here waiting on her because I knew she was going to bully me into feeding her again. Here you go. Here you go. What are we thinking? How are we feeling? Sidebar. It's time for a sidebar. Everybody's asleep and hungry. I know. The technical stuff is not the most fun. It's not the most entertaining. Especially when they're reading out.
I do.
All right, go ahead, Mr. Kennedy.
When they're reading out all
Having
the
reviewed your
numbers.
reports, can you testify to the jury about who it was that brought this evidence into the lab?
So you can tell us.
Okay. So submission 7, all the items that are 7 dash, was submitted by Trooper Michael Proctor.
Were you aware of the date of the incident that gave rise to this case?
Yes.
And what was that date?
January 29th, 2022.
Were you aware that the clothing that you received was seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought to your lab?
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me that was about 6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of 2022, correct?
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained.
Do you know where Michael Proctor stored this clothing during that 6-week period?
No.
Do you know how often he was alone with access to the clothing during that 6-week period? Do you know if he had access to pieces of red or clear taillight during that 6-week period?
Objection, strike out.
Sustained. Move on, Mr. Kennedy.
Improper question, so it's right to be sustained. But yeah, he got it in.
You were not present when the clothing was seized, correct?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Kennedy. Move on, please.
One last question. You cannot vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
I cannot.
Anything further, Mr. Lilly, or are you all set? I'm not cribbing it.
No. Very good.
Mr. Vallier, there is a separate evidence unit contained within the Massachusetts State Police Crime Laboratory, correct?
Correct.
And fair to say you have absolutely nothing to do with that, correct?
I'm not a part of that unit.
And so your responsibility as far as chain of custody is concerned is from when you retrieve the item during your analysis and then when you return the item to the evidence unit, correct?
Correct.
And from that analysis that you performed, you found that there were 10 different items, starting with the number 7, that were a mechanical fit to 3-1, the taillight housing from the defendant's vehicle, correct?
If it's 10 items, I don't have, I can count them.
As far as all those items beginning with 7 that you went through or elucidated on your direct examination, each of those were a mechanical fit to each other and then to the taillight housing in 3-1.
The pieces that were previously stated, yes.
Nothing further.
All right, Mr. Lucia, you are all set. All right, so jurors, that is it for today. I'm told when I spoke with counsel earlier that we are still on track. I have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and Friday is a day off.
Oh.
All right, so we'll see you on Monday.
Please rise for the jury.
Oh my gosh. That's it for today? What? Unless they're about to come argue. And then we have to sit here and listen to them argue. Let me see.
You may be seated.
Okay. So before we recess, I appreciate that council provided me with the information. Mr. Leslie, I got the 2 reports that you had that were incorporated and what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections are noted. I'll see everybody on Monday.
All rise for the court, please.
Shocker. 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 The defendant has not persuaded me of undue prejudice. You know what's wild? Brennan just got up there and misrepresented everything once again. and gave Bev an easy out. Could you imagine if the defense came in and was like, oh, by the way, we have this change that we want to make right now? The judge would yell at them. Brennan would, you know, and there's nothing that anybody can do. It's just, this case is not the Commonwealth against Karen Reed. It's the Commonwealth and Hank Brennan and Judge Cannoni and Massachusetts State Police and the Canton clique. Marie Moss with our official stats. 2 witnesses, 3 sidebars, 14 objections. And with Lally on deck today, 13 what if any's. I'm not surprised because I said it a minute ago. I was like, I think she'll give it to him because it's like, you know, she's like one of those parents that gives your whiny toddler a that like gives them what they want. Judges even allowing the defense to say that the prosecution ignored the sequestration order. Like, what? There's no way the jury doesn't know what's going on when they leave. I don't know what all they know. It's an interesting. I can't help but wonder like how much of all of this they pick up on, because, you know, all of this stuff is done outside the presence of the jury, and they aren't privy to all the stuff that we know from the, you know, for the last 2 years. My silence is scaring you. Yeah. I mean, I shouldn't be surprised. It's just, it's like one of those things that when you see it happening, you're like, okay, they know that the world is watching this. So she wouldn't possibly, but she would possibly, because she doesn't care. The good news is, since we're off early today, I will be able to get the podcast episode done today and actually have a day off tomorrow, which will be amazing. But also, you can pretty much guarantee that my thoughts will be in it. She doesn't find that there's delayed disclosure. Sis, we're almost at the end of trial. Did she say half day next Thursday and no court Friday? Yeah, and isn't let me pull up a calendar. Isn't that weekend? Yeah, and then I'm assuming we'll be off Monday for Memorial Day. That's my daddy's birthday. So it looks like we're getting a long Memorial weekend, which is great because I think we all need it. Oh, that'll be amazing. Chat Daddy, are you watching? Let's come to the beach that weekend. Oh. Because isn't Monday? Monday's the 26th. It's Memorial Day, isn't it? That may be because you know how some jurors will have plans already. Candace Hoff said, I needed to grant a half day and then a full day. It's crab walk season. There you go. Yeah. So, okay. So it looks like we'll be getting a long weekend. So not this weekend. Next weekend, we'll be getting a long weekend. So I will see y'all back on Monday. I'm going to use the rest of today to get the podcast episode done so that I can actually have a day off tomorrow, which will be amazing. And my husband did not just say, I'll allow it. When I'm talking about let's come to the beach for Memorial Weekend, I'll allow it. You're cut off from watching Auntie Bev. I need to be heard. I'll allow it. You're cut off. Chat Daddy's cut off. Can you explain how this report is different than the Crash Daddy's report coming in? Well, it's different for a few reasons. So I know. I still need to be heard. You just wait. As soon as this is over, I'm going to be calling you. Okay, so yeah, this one's a little bit different from ARCA. So the thing with this is that the stuff with ARCA is not, how do I say it? Like the new stuff with ARCA is them doing a like rebuttal against the prosecution's stuff from Aperture. So that's like a response or a rebuttal or whatever, which is like kind of what they do for that's the defense. There's no like new testing, whatever. It's like ARCA is in response to the prosecution's crash daddies, crash uncles, whatever. This is different because this is like them coming in at how am I so calm? Because I'm not calm. So when I'm not calm, I seem very calm because I have to be mindful of what I say. I'm not calm at all. But anyway, the stuff with ARCA is that's part of their rebuttal toward Aperture. So that's already been decided, discussed. They were given the deadline and they met it. So now we're like at the end of trial And that was all based on stuff that, they got right before trial started or whatever. Brennan even said, what do you call it? Like a voluminous amount of information that they gave the defense, like right there on the day of deadline or whatever. And it's like the 141 slides and then all this stuff, whatever. So they let the Crash Daddies do their like basically rebuttal to that. And so now it's like, now prosecution's coming back in and wanting to change stuff that has already impacted stuff that has already been presented in the case. So it's different because I'm trying to think of the right words to explain it. Like, what's done is done now, and now the prosecution is coming in saying like, oh yeah, we're changing this. So now it changes all the stuff that's already been done, like the entire way that the defense has been presenting everything. What ARCA gave is a rebuttal to what the defense or to what the prosecution gave. So them giving that doesn't change anything about the prosecution's case. It's a rebuttal to that. This is different because it's changed. It like this impacts the way that the defense has already done everything. So and we're like at the end of trial now, and they're wanting to change it. No case has ever done this. Why is Bev breaking all the rules for Hank? They read ARCA's response to their investigation and realized how wrong they were, and they're changing theirs now to make ARCA look stupid. Have you noticed that Hank Brennan, with every argument he makes, he never argues facts. He always argues like in a way that insults the other expert. That's what that's part of why I can't stand him either. I like to hear all the information. They may ask for mistrial. She will deny it, but they may ask for a mistrial. He is changing. They are changing the prosecution is changing what they're doing based on testimony that has already been given. And because it doesn't make sense, and now the defense has to just deal with it. That is wild to me. That is wild to me. Cut to the chase, ramble, ramble, ramble. Yes, I have severe ADHD. I cut to the chase when I can. I will ramble, ramble, ramble a good percentage of the time. I know that doesn't work for everybody. I wish I were, could do it differently. I can't. It's just how I am. I get there when I get there, and we often take detours. Basically, this is allowing the prosecution to rebut the defense, which should then allow the defense to rebut the prosecution, and on and on and on. Not how trials work. It's not how trials work at all. At all. It's crazy, isn't it? He should be able to stand behind his experts, but he can't because he knows they're wrong. That's the thing, is like his experts are saying different things than each other. So now he's trying to fix that because the prosecution knows that like that's a big problem. And everybody in the media is pointing out what a big problem it is. So now they're like, oh crap, we need to fix that. Look at all these issues. We're just gonna sneak in and do it. No problem. It is wild to me. I'll be interested to hear Lawyer's No opinion on this one. Yeah, he's a great one to listen to. I love hearing his legal opinion. Well, we'll see how it goes. I will have a lot to say in this week's episode. Also, the podcasts are scripted, so there's less rambling in those for anybody who wants to listen. Do y'all think, let's do a poll real quick before we go. I want to know if y'all think the defense will ask for a mistrial. Do you think the defense will ask for, it'll be denied if they do, but I want to see what y'all have to say. I like hearing y'all's feedback. Imagine being in a jury, making a decision, and then finding out about this afterwards. What is that show? Or it was like a documentary where they had the jurors who acquitted the guy for something. And then, but there was like a lot of information they weren't allowed to know. And then they found out after and they were like sick about it. They were like, if I had known all of this that was kept from us, there's no way. I can't remember what it was. Kim Nash says, as a fellow sufferer of ADHD, I'm thoroughly impressed with your ability to listen to the boring testimony and log it quickly and accurately. I'd have to double up the prescription. It's tough, man. But that's why I have to take notes. And that's why, like, when like on this stuff like today where it's boring, you know, I'm like, I want to chat with y'all, but I have to write down these notes because if I chat, there's no way I can pay attention to what's being said. Yep, we're done for the day. The judge would grant, Casey Freeman says, who grants the mistrial? The judge would grant the mistrial. So. I don't think that like the trial is overall, like the trial is going good for the defense right now. Hank Brennan is trending on Twitter right now. I don't understand why Auntie Bev is the one that gets to decide if she should be removed from the case. Well, that's the thing is like judges have a lot of discretion. a lot. Are you able to do a very quick recap of what just happened for those of us that just joined? We made it through. I'll do my recap video today with top moments from the case, and I'll break it down too. But basically, we went through our 2 witnesses for the day. That's all we had, right? DNA dude and taillight chick. DNA dude went. I put a graphic out, and it's in the spreadsheet of all the DNA stuff. Basically, there's unidentified DNA on John's clothes and shoes, and the cup and the taillight, and then the taillight pieces were all turned in at different times. She basically went over how she compared them, what fit together, what fit together and what didn't, and how they did all of that. And then at the end of the day, Judge Canoni ruled that Brennan can basically just do whatever he wants, and the defense is just going to have to deal with it. He's basically he wants it's not even just the changing of the report either. I'm curious to see where this goes with the with having the Aperture dude come back and do the rebuttal of ARCA too, because she said she's going to keep that like in a limited scope, but how limited is she really going to be, like, keeping it? Because it'll be like, oh yeah, we're going to limit it to whatever Brennan wants. It's like he's asking, and it has been granted, to not only have this report entered in and changed, but to have his dude literally like keep testing, keep working on the case, and then come back again after ARCA testifies and say whatever he wants to say. Like, it's wild to me. It's wild to me. I don't know. I guess we'll see. I have a feeling a lot of the lawyers are going to have big opinions on this too. So I'll be interested to see what they say. But all right, that's it for today. I am going to start working on the recap for today and the podcast episode, and get all that going. Go read Howie Carr's post about the juror note to Bev. All right, Howie Carr says, earlier this morning, it says, is Auntie Bev feuding with the jury? Because, she admonished him this morning. Earlier this morning, she admonished the jury as to how to react to evidence. Never heard a judge say such things in America. But then, we're not in America, we're in Norfolk County. So this is coming from Howie Carr. He says, now I get a tip from someone in the know who I've known for a long time. Here it is. Take it for what it's worth. It says, good morning, Howie. If you've noticed, Canoni has drastically changed her demeanor during the last several days, less hostile toward the defense attorneys, a little hesitant to automatically sustain a Commonwealth objection. The information is third hand, so here goes for what it is. So this is all third hand. The word is that the jury sent her a note through a court officer that they wanted her to stop automatically sustaining all of the Commonwealth's objections because they felt it was unfair and they wanted to hear the witness answer. And this information has come from a court officer, hence her change in judicial demeanor. What if they did hear the hot mic moment? All right, I'm going to end the in the poll. All right, so 72% of you think that the defense will ask for a mistrial. I don't even have to poll to find out how many of you think that it would be granted. Nobody. Nobody. All right, y'all. That's it for the day. I'm going to go get all my stuff done. If you have not checked out yesterday's recap video, check that one out too. That one was, because there was a lot going on yesterday. Also, there should be a video out probably today about the buffer zone update from yesterday as well. So look for that. So y'all should have a lot of stuff. I may not see you this weekend on a live, but I will be with you in spirit and in the podcast episode and in the recap videos. And then I will see y'all Monday. Monday, I'll be back at the house, so you'll have Zoo Crew Cam instead of Lucy Cam. So you'll be able to say hey to the whole crew. And we'll have defense camera back up because I'll have my third monitor there. Thank you for suffering through with no defense cam the last couple days. I appreciate every single one of you. If you have not hit the I didn't like it, I acknowledged it button yet, please do so. And I will see you all bright and early on Monday morning. We have Monday, Tuesday, and Wednesday are full days. Thursday is a half day, and then we should be off next Friday and next Monday with a long weekend. So we're going to make the most of next week. And the Crash Uncles may be testifying next week. So we'll see how that goes too. We'll see. I'm going to be watching the docket too because I have a feeling. I have a feeling. All right. I love you all. Thank you so much. I'll see you Monday.